you guys. My goodness, we got some stuff to talk about. So, first of all, wave at me if you can hear me. Ship, I see you. Can you hear me? Okay, folks are waving at me. Ship, unmute yourself. I can't hear you. And Kingmaker should be joining us here momentarily.
No, I'm here.
I don't know if I have laughed so much about something happening in court as I did today. I don't know how long that's been. I didn't get to watch most of it because I had stuff I was doing today, and actually this evening also. But I was, following it a little bit on the news and on Twitter, and I, it just is mind-boggling that hearing. Chip, were you able to watch some of it?
I had it open on my computer on Twitter. I found a live stream, so I was able to sort of keep that open and then work in another screen. So I just sort of, it was kind of background noise. I probably paid more attention to Wade. I didn't actually realize when Willis came on, so I probably missed more than the first half of her, but picked up. Yeah, I didn't have to listen to her too long before I, sort of got the
gist.
Right. Willis. Well, Wade was the one. Wade was the one who was really in jeopardy because of his answers under oath in the divorce case, which were, counterfactual, as they say.
Counterfactual, yes. Alternate facts. Ooh. All right, Kingmaker says he's ready, but he's not in the speaker box yet. So let me see what's going on here. Wow. That was just a wow, you guys, the whole thing.
Yeah, almost as much a wow is looking at some of the Twitter commentary by, people on the other side of the spectrum
like
who are
Norm
praising her performance. Like,
she's obviously telling the truth. No, dude, she's obviously lying. Gee, Ooh. So, well, and I tweeted this out. I was not expecting the, unable to perform defense to the affair allegation. That was spectacular. Good grief!
I was struck by
There's King.
My marriage was irretrievably broken in 2015. So, for purposes of answering questions about my marriage, I simply answered them as if I was divorced in 2015.
Right. Yeah, I know. Right. So I was actually still married legally, but hey, okay. But our culture has gone that way. Have you noticed this? Like people will say now, "Oh, that's her ex, her ex." That you see this in pop media all the time, and it's like they're still married. He's not her ex yet.
Or they were never married.
Right. It's just like, okay. Yeah. Hey, King, you there? Can you hear us?
I'm here, and Leslie, did you notice? I'll ask you because you're probably more astute at this than Ship and I, but that Fani showed up in a pink dress, hot pink dress.
Hot pink dress.
And it's the mirror image of the hot pink dress that Miss what's her name, the Roman's lawyer wore at Monday's hearing.
Oh.
She wore a pink dress.
Okay.
And so Fani decided to match her today.
Okay. Well, as I'm sure everyone knows, I'm of the view that women lawyers should be wearing suits, not dresses. So, but we probably shouldn't revive that controversy. So, all right. Well, King, I was going to interview you and Chip too, since he saw it. I didn't get to see most of it. I was just following a little bit of the play by play on Twitter. So let's kind of start from the beginning. And then,
Before you ask me the first question, can
uh-huh,
I start with a old lawyer's war
sure,
tale?
sure, absolutely. War
This
stories
is an
are welcome
absolutely
here.
true, verifiable war story from an
Okay.
ancient lawyer. Back when I was much, much younger, I was trying a a massive, uh, multi-party civil construction case for the first time out of my uh, bailiwick. First time out of state that I was doing a
Mm,
case,
okay.
and many millions of dollars involved. I was really young. I was full of myself because
No.
I got awarded this case as the lead lawyer,
Mm,
and the other side, one of the other defendants in the case, I was looking for a couple $1 million
okay.
for my client, and in contract damages. And the other side put up an expert that had changed his expert report at the very last minute, and we
Uh-huh.
didn't have time to depose him.
Okay.
So I was cross-examining this guy blind
On the fly. Right.
on the
On the
fly.
fly. Right.
Basically, he said my damage claim should be cut uh, into a third of what we were claiming. So I stood up to cross-examine him. His direct was very vague, very broad, very
Mm,
general, not very specific. So I had no clue where he was coming from or what the holes were. So I kind of thought I'm smarter than that dude because here I am in my first big case, so I must
mm.
be smarter than him. So I stood up and started crossing him, and I asked a couple of questions, leading questions, and I finally ended up with a answer: yes, but. And
Mm.
he went down. He articulated a rabbit trail, totally different from what I'd asked him.
Right.
So I launched down that rabbit trail. And when I got to the end of it, I got another yes, but
Uh-huh.
with a third rabbit trail.
Right.
And after about 10 minutes, 10 or 15 minutes of this,
Mm.
the federal judge, interjected. Mr. King, there are certain witnesses that we here in East Texas call tar baby witnesses.
Oh.
He said, you hit them once and you bury your arm up to your elbow. And so you try to hit him again with the other hand and you bury your arm up to the
Mm.
elbow and on and on. And he said, Mr. King, we're going to have a 10-minute recess. And when we come back, I want you to tell me whether you have any more questions.
Okay.
And when we came back, I said, no more questions, Your Honor.
Right.
That's kind of what we saw today.
Oh wow, it's just unbelievable performance, and so on so many levels, and by the judge too, in a way. And I know people had a lot of questions about that, like why is the judge letting her do that, and is he going to let President Trump do that? The answer to that's going to be no. So, but okay, so let's lay the foundation for people. The purpose of the hearing was what?
It was to the judge had narrowed it, and the hearing today was pretty much limited to whether or not there was a conflict because of a personal and financial relationship between Fani Willis and her lead prosecutor that she had appointed and hired as the special prosecutor for the case. And he was more or less in charge of the whole thing.
Right.
And And that was the issue. Did that potential or actual conflict disqualify both of them from sitting on the case? And if so, did that conflict require one, the DA's office in Fulton County to be taken off the case, and two, whether the conflict was sufficient to require dismissal of all charges?
And
That's what is before the court.
all right, and the judge took evidence on that today. Did they finish the evidence?
No, we're going back tomorrow.
Great. Second verse, same as the first. All right. Okay. And this judge, you've been watching him. Do you think it's likely that he'll rule at the end of the hearing from the bench, or will he take some time and then issue a written ruling?
He announced today that he is not going to rule from the bench. He's going to
Okay.
take a little time and probably write an opinion.
Okay.
I'll give you my bottom line conclusion.
Yep, that was my next question. What do you think? Let's start with that. We can work back to it, but go ahead.
Yeah, to find an actual conflict, he's got to make some serious credibility calls. This witness lied. This witness did not, etc. Because both Fani Willis and her boyfriend, her ex-boyfriend, testified that they didn't have an affair going before he was hired. It only happened after he came on, after the case began, and it's now finished. So, if
bad?
They broke up
They
last
broke up.
August. They broke up
Oh,
last August.
okay.
Well, the interesting definition of words there. Fani testified that from a woman's standpoint, they broke up last August because that's when she had the talk. From a man's standpoint, they broke up before that, maybe June. Apparently, when she cut him off.
Oh, when she stopped sleeping with him?
That's
Okay.
it. Yeah. So June to August, they broke up. There's been no contradictory testimony to that. So the issue is,
It's all good. It's all good now. They're not
well, the
seeing each
issue is,
other
does their
anymore.
sleeping together throughout most of the case and most of the grand jury investigation somehow taint this case because of a conflict,
Right.
and both a financial and a personal conflict.
Right.
And
Now, what was your takeaway? Did you think the evidence supported that they were, in fact, sleeping together? And by that, I mean having sex, not just being in the
they
same
admitted,
room.
both of them admitted to that. Yes.
Okay.
Yeah.
There
And
seemed
both
to
of
be some question about his capability.
no, well, no, they both were admitted to that.
Okay.
The big issue was, when did it start? But both admitted that at no later than February, March, April of 2022, it began.
Okay.
So yes, they were sleeping together. They were traveling together. They were spending nights together. And they had a very romantic and sexual relationship.
Okay. So did the judge say what he thought the potential bases for, like, the actual conflicts were, both personal and financial?
Judge
Did he
didn't
give that?
comment on that, but he
Okay.
he 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 steered the evidence to what he believed the issues on that were.
Right. That's where I was
Which
going with that. What do
Yeah.
you think the judge thinks the actual issues are?
Well, the actual issues are: one, did they have a romantic relationship that could be or might be a conflict? And two, did that relationship rise to the level of a financial benefit that she got from hiring him as one of the prosecutors? And there you have,
Because her office is basically funding his employment or his income, right?
not only that, but he was taking her on trips.
Right. So he's spending his income that she's funneling to him on her.
Correct. And so,
let me jump in here, King, real quick. I think there's actually one more wrinkle to that, and that is his income goes up the more complex and extensive the indictment becomes.
Right.
So
it's not
in a
like a small amount of
way,
money. This
to
is like
have
a
a
2-week
to have
trial.
a sprawl,
Right.
to have a sprawling, broadening, all-encompassing, wide-ranging RICO case with 19 defendants means he gets paid more.
Ship, you and I came from the same place, because that's been my main point all along. But nobody on the defense is arguing that, and I didn't hear any evidence of that today.
Okay. Well, maybe they haven't got to it yet. All right. So tell us. I saw some stuff early on. The defense got up right away, ready to go this morning, but there were witnesses that didn't show up for court, or they came late.
Let me go back. Miss Merchant, that's whose name I was escaping me earlier. Miss Merchant.
Now she's the lawyer for one of the co-defendants,
pink
right?
dress lawyer for defendant Roman. She had told the court on Monday, in response to a motion to quash by every witness inside the DA's office that she was trying to subpoena, she represented to the court that all these people knew about this relationship, and I can prove it. And the judge asked her, "How can you prove it?" Well, I can prove it with Mr. Wade's former law partner. What's his name? Bradley.
Right.
And the judge says, "Okay, we'll put Bradley on first to lay a foundation for all this impeachment evidence, because unless you have something, if you're not just totally fishing and making assertions without any evidence, this is not going to go very far." She told the judge, "Yeah, I've got one witness I've talked to, Bradley, and he opens the door for everybody else." So we get to the court today. They get to the court. I'm watching on TV, and she wants to put on another witness, Miss Yurty, who had worked in the DA's office and had owned a condominium. And when Miss Yurty got married or got engaged, she moved out and Miss Willis moved into.
Is this the place that she's living where she doesn't know how much the rent
That's it.
is? Okay.
So Miss Yurty was going to be her first witness. She changed their order, and she apologized to the judge that said, I held back some of my evidence, and I'm going to go this way and not with Mr. Bradley first. Well, Miss Yurty wasn't there, so she had to call Bradley. And anyway,
okay. Now this Miss Dirty, she showed up later though,
she
right?
did
She was
show up
just late.
later, but
Yeah.
and fortunately for Miss Merchant, because in trying to get Bradley to say what she had told the court he would testify to, it comes out that Bradley was Wade's lawyer in the divorce case initially. So he
was the law partner.
He was law partner and lawyer in the case, and he testified. I have to plead when he's asked about Wade's relationship with Willis in the past. He says I have to claim attorney-client privilege, And he says, I represented Wade in the divorce, and I knew this was coming, so I asked the bar association, and they told me I
Right.
couldn't talk. I had to
Right.
say attorney-client privilege, and go to jail if necessary. But I
Right.
can't answer. So Miss
Okay.
Merchant was kind of hamstrung, and then it was
Yeah.
announced that Miss Yurty had showed up.
Okay. So Bradley's
He's
off the
off the
stand. Is he
stand.
going to come back, or is that the end of him?
He could come back, but I doubt it, because she didn't. Nobody did any examination of Wade as to the scope of attorney-client privilege,
Okay.
because
No,
Okay.
oh, wait,
All right.
wait,
So
wait, King. Hey, wait, King. No, Wade was asked if all of his conversations with Bradley were about attorney-client matters,
and
and Wade said
yeah,
no.
but
He
that was
said
the
that,
last question. They didn't go
yeah.
further. They didn't say where did the
okay.
attorney-client privilege start and where did it end and what was the scope. Nobody asked him that.
But I think they can ask Wade. I think they can ask Bradley that
They're
to
not going to get
exclude
an answer. He's going to
attorney-client.
say I can't answer.
He
It's
might have to
Wade's
answer some of
privilege.
those
They had a
questions,
chance.
but
Yeah, they
yeah.
had a chance, but they didn't ask him.
Yeah.
But anyway, Miss Yurty
Okay.
takes a stand, and she says they were good friends. She and Fani Willis since college, and she owned this condo and lived in it uh, outside of Atlanta, and she was not only friends with Fani Willis, but saw her regularly. And to sum up, she said uh, they had a relationship. It was romantic. I could tell because they kissed, they hugged, they were affectionate to one another. And she admitted it to me. All of this was going on before November of 2021, when he was hired by the DA's office.
She said it went back to 2019, right?
Shortly, yeah, the two of them met. Willis and Wade met at a conference in October 2019, and she said it was shortly after that it all began.
Okay.
So, and nobody had anything to rebut that.
All right. And that's what was one of my questions. Was there any cross of her? Was there any good impeachment of her?
Not really. No, nobody touched her.
Right. Okay.
Other than
So
to
help
show
us.
that she did have a axe to grind with Fani, because she was working at the DA's
Ah,
office, and at some point a couple of years ago, she was told to either resign or she was going to be fired. So she turned in her resignation.
okay. So she's actually, that makes her more credible. Great. Poor Fanny. Okay. So who is representing? I mean, Willis isn't personally she's a witness, right?
She's
So
got a very good
who
witness.
from her
Yeah,
office?
she's got a independent outside the office, similar to Wade. She's under contract. Uh, Miss Cole.
Is she specifically engaged to defend this motion, and
Yeah,
is that it,
she's
or
defending the motion on behalf of the DA's office.
of the
Right.
office? Okay. All right. And but did Willis have her own lawyer there too, or
If
not?
she did, nobody spoke.
Okay. So this Miss Cole is the one who was trying to quash Wade Willis's subpoena.
Correct. Yeah, and was
All right.
doing a damn good job of arguing
Yeah.
why Miss
Until
Willis didn't have to take the stand. Uh,
right.
Step back a minute. The rule is that when you subpoena somebody at the top of a governmental organization, like Secretary of State, like uh, head of the CIA, like head of the SEC, or like head of the Fulton County DA's office, the general rule is you have to exhaust other avenues of getting your evidence, because
before this important
those
public
people are
officials
so
or
important,
have
they
their
don't have
time
time.
wasted. Yeah.
Right.
Right,
So
exactly. Now, but I mean, usually that rule is suspended where the person clearly has personal
nobody said
knowledge.
that.
Right.
Nobody argued
Oh,
that. And so they
yeah.
were, the DA's office was doing a bang up job of arguing that point. And this was after Miss Yurty and Mr. Wade both had testified. And they said, Miss Willis has nothing to add. Mr. Wade was there. He can testify to
Right.
all of it. There's nothing she has to add.
Right.
You don't need her. And in the middle of the argument,
That's a good point,
Fani
actually.
Wade walks into the courtroom and says, "I
She
want to
shows up,
testify."
right? So she has herself for a
Yes.
client. We all know how
and
that goes.
and the camera zoomed in on her, and she was mad as hell. You could.
She's not going to take it anymore.
She wanted her to speak her mind. Whether this was all pre-planned, I have no idea.
Well, do you think this is one of my questions? You guys think she was watching it on the internet? Because
Absolutely,
I
she was
guarantee
watching this.
you she
Yes.
was. Yes. So she watched her boyfriend make a total mess of it and her friend throw her under the bus. So she decided she had to go down there and straighten it out. Oh, God. All right. So Miss Jerky, is that her name? Jerky?
Yurti,
Jerky. Sorry.
Yartie, I think is how you spell it.
Okay, I'm not intentionally trying to mispronounce her name, people. I have trouble with names. So Miss Yerke, she didn't testify very long,
She
right?
was very short. Mr. Wade was long, and that was interesting. Very interesting. He's slippery as hell. The unfortunately, here I don't have much criticism about defense lawyers in other cases because you never know. You're on your feet. You got to plan ahead of time and stuff. There was one part of his testimony that kind of got lost for a long time. It wasn't until the second lawyer came up.
Well, let me ask you. I'll ask you about that because I couldn't understand why were there different lawyers. So Miss Merchant
Yes.
is the primary defense lawyer who's conducting the examinations, but there were other defendants lawyers asking questions too?
Yeah, every defense lawyer who showed up was given a chance to say something or ask questions.
Okay. Was
I
the
think it
former
wasn't.
president
Yeah, it wasn't
president's
clear.
lawyer there?
Yes. It wasn't clear who was representing who. That was part of the problem. Nobody was giving. Well, the live stream I had, nobody was giving kind of like a play-by-play. Who's this? Who's that? Merchant represents the movement, the defendant Roman, who made the motion. The interesting thing there is Roman is one of three individuals the grand jury did not recommend indicting, but she indicted him anyway.
Oh, nice.
That's the only reason he's in the case, and it's his lawyer. Now, I read a story, I think it was in the New Yorker just in the last couple of days, that said this information about Fani Willis and Wade was not unknown among lawyers in the courthouse. And in fact, there's another sprawling RICO case that's currently underway involved. It took like a year to pick a jury in this other case. A year to pick a jury. And one of the lawyers in that case, gave a lot of on the record comments about this in this profile or article. But Trump, I believe it was Trump's lawyer, King, who was up second each time. Gilliland, I think was his name.
No, he's not Trump's lawyer. Okay. Trump's lawyer came third.
Okay, the third, right. And that, something I didn't hear at all, didn't Trump's lawyer raise the issue, and maybe they put this off for a different proceeding, raise the issue that her going to the church and essentially calling all the accusers racists, violated all kinds of ethical norms and as a grounds for disqualifying her, because basically she's the prosecutor, and to the jury pool, the broader jury pool in the community, she's saying the defendants are a bunch of racists.
Yeah, well, the judge didn't want to hear that. There's some other issues raised in the motion that he didn't want to hear. He limited it to the conflict issue, this hearing.
Now, meaning he's not going to entertain those issues at all,
I
or he
think
wasn't
he's
going to
going to.
entertain them at this hearing?
In this hearing, he needs evidence on the conflict. I think he's thinking that those other issues can be decided on the papers.
Okay. All right. So, of course, people know. I think that's, fairly common and understandable that people would know about it. But not a lot of defense lawyers would raise it, nonetheless, right? There are all kinds of lawyers, defense lawyers, who would be squeamish about raising this issue and not raise it. But this lawyer Merchant is, by everything I've seen and heard about her, is a very good defense lawyer. Isn't she currently like the president of the Georgia Defense
I think
Bar?
she is,
Or
and she has
yeah,
some skill. There was,
right.
if I can be critical, with all due respect to Miss Merchant, who I thought did a very good job considering, but there were a couple of things that I do criticize her for, and I'll explain why. She started off her cross of Nathan Wade with the statement that she and he used to be friends. She was
Oh,
a supporter of his campaign for judgeship that he lost. On the internet, there's a picture of her and her kid wearing Wade for Judge T-shirts.
now why would you bring that up? I
She
mean,
brought that
that's
up to start, almost to
mm-hmm,
apologize to him for the question she's
mm-hmm,
about to ask. And if she's got to do that, I think as a lawyer, as a defense lawyer, she should have gone to the other co-defendants lawyers,
mm-hmm. Right,
and they should have gone to her and said,
right,
turn this over to somebody else, because
right. Let
what
somebody
needs to
else
be done
examine
here,
him. Yeah,
you need
yeah,
a rabid mad dog to go after Mr.
right.
Wade because of something I'm about to tell you. And she basically let it alone, and it took the second
Mm,
lawyer to get up to even bring it up, and it
mm.
was weak. Uh, which is this: in the divorce proceeding uh, that Wade filed the day after he was hired by the DA's office, uh, his wife of 20 some odd years uh, propounded interrogatories, which are for lay people out there. That ask for written answers to written questions as a form of discovery, and they have to be in most places they have to be verified, sworn to, or certified by a lawyer as being true and correct. Um, and he and he was asked whether during the marriage, including the period of the separation of the couple, have you ever had sexual relations? Who did you have sexual relations with
Oh,
other
the
than the
wife wanted to
wife?
know.
And he
Okay.
answered none.
None. Oh, wow.
These
Well, this was during this period of
interrogatories are
time where he was
dated.
married, but he didn't consider himself
Yeah,
married.
yeah.
Is that the
Well,
period? Yeah.
I'm going there. They're dated like 2023. Uh, he answered none, and then she asked, uh, "Please identify and produce all receipts
Mm.
of bar tabs, hotel room receipts,
Hotel
you know,
rooms,
dinner receipt, dinners, you know, uh, where you have
restaurants, right? Yeah.
entertained some other woman
Right,
during the marriage or during the period of separation until the
right,
present. The word present
right.
is used. And he said
Mm-hmm.
none.
Oh, okay.
So they had him in a flat lie.
Flat
And we
out lie.
know that
Let me ask you
because
this.
because when this all got filed by Miss Merchant, he went back to the divorce case and filed an amendment to those two answers.
Amended. Oh, he updated his
Well,
answer.
no, he amended the answers, and instead of giving an answer, he pled privilege.
Oh, he pled the
And
privilege.
the
Okay.
privilege he cited as a statutory Georgia privilege that
Mm-hmm.
that says a privilege against self-incrimination
Yeah.
or something infamous or scandalous, something that embarrassing. You have a privilege not to disclose those things. So he cited the statute without saying what it was that was the basis
What
for
it
the
was.
privilege.
Yeah. Well, I mean, in a divorce case, the question of adultery is totally relevant, right? That I assume that's still a grounds for divorce in
And
Georgia.
it's a
Is it?
ground.
Do you know?
It's a ground in the equitable division of the property.
Right. It's a difference. Some places that's not true, in other
In
places it
Georgia, it
is.
is.
So
So
yeah.
And then on examination, they he clarified that he was not asserting that privilege as attorney-client privilege, and then he even said he wasn't even really asserting that as to the second part, but that it was just a general assertion of privacy because it had become
Oh.
his divorce had become entangled
yeah.
in the public spectacle of this
So
trial. So he just decided that he was entitled to not have to answer any of those questions or
Oh.
out of privacy concerns. That I listened to that though, and I thought
That's not a
that
thing.
that doesn't get you away from your previous answer of none. You're not
well,
correcting
Right.
the
he had
answer.
an answer for that one too, Chip. He said the question was marriage, and as far as I'm concerned, the marriage was over in 2015 when she had an
The marriage had
affair.
broken down,
So
Chip.
so
I
we
mean,
agreed the marriage was over, but we
hmm,
stayed together because of the kids. So
hmm.
so
He was saying she'd had an affair before
he
already, the
says
wife.
that she denies it,
Uh-huh. She
but we
denies
hadn't
it,
heard
right?
that. That's not in evidence yet. But he said basically
Oh.
the marriage is over in 2015. So that that allowed me to say none to both answers.
I love this. This
But
is the
that
well
wasn't
in
the
my
question. The
mind
question
answer.
wasn't when you were married. The question
In his
was
mind, that was
through
the
the
question.
present.
Oh my goodness. Well, and it's problematic to lie in your case, but it really is problematic when you're a lawyer doing it,
Oh yeah,
right? Like
and,
this
and
is
that that right there was a barn door that was opened wide as it can get for a lawyer to jump into issues like, all right, what's your definition of marriage? What's the legal definition of
right.
marriage? If a man and woman
Oh my
get
goodness.
married and decide to live apart, are they married? Is that a marriage? And you
Right.
can go down
Mhm.
all kinds of you can twist
Right,
him.
because even if he's saying that she condoned it, okay, but that's still a point of proof. If
It's a
he's saying we
marriage.
agreed to
It's
see other
they're
people,
married.
right?
They are
Exactly.
married. He
Right.
could not have
Yeah.
legally
Yeah.
married anybody else. And the law recognized
Right.
that
Exactly.
marriage until there was a divorce, and there hasn't been one yet, by the way. There
Right.
hasn't been a divorce yet.
Right. So right. So folks know, like even if they had agreed, okay, we're going to see other people, they can have that agreement, but that doesn't mean that her lawyers aren't entitled to explore this issue for purposes of the divorce, right? So like you just can't decide
It's
I don't
not
have
only
to answer these
it's
questions.
Leslie. It's not only can they have the right to explore it. He didn't object to the question as being irrelevant. He just answered it
Right.
falsely.
He just said
He
no.
said none.
He just gave a false answer.
And the question is, well, how is the answer none? You know, in any way embarrassing or
Right.
threatening of any way, or
Right.
even not even private. Why is
Yeah. Yeah.
none private?
Yeah. Good grief. Well, so and some of this was being reported, but what wasn't being reported was things like, and what was the judge's reaction to? Did the judge show any
No,
reaction
he
to the
did
fact
not.
that this lawyer obviously
He
lied in his?
he knows Wade lied. Yes, he knows Wade
Mm-hmm.
lied. He knows Wade's excuse for lying was lame. Uh, so yeah, every lawyer in the courtroom and particularly the judge knew he was lying.
Something when I've got a client who I think is going to testify or somehow, trying to, just we're trying to come to an agreement on how we're going to approach the case. The one thing I always say is, you know what? There is no benefit to denying the obvious.
Right.
All it does is, not only do you still lose, you
Right.
now have hurt your credibility.
Well, and now
He,
you lose on issues you wouldn't have lost on because
yeah,
people
he
don't
should have
believe
just
your
said,
lying ass.
yeah, he should have just said it was an untruthful answer. I was having an affair with Miss Willis. Then he's
And I
stuck
didn't
with
want my
having made
wife
an
to know.
untruthful answer. Right.
Right.
He's stuck with having made an untruthful answer, but he still is intact for
Yeah.
answers to come. But it's like you so clearly lied here, and you won't even admit you lied here.
Right.
How do I credit anything you say after this?
Well, because a judge might easily find that it was, he understood he lied in the divorce proceeding, but has he lied to this judge having anything to do with this case? Right.
Why limit it to that? He is trying to put people in jail for lying to
Right.
courts. He
Well, yeah.
lied to a court,
Right.
black
I
and white. He lied to a court, and he's trying to get
Yeah.
out of it, but saying, "No, I didn't lie. I just tried to mislead everybody."
Well, but that doesn't go to the conflict of
No, it
interest,
doesn't go
right?
to
That
the
he lied to
conflict
the
of interest,
divorce
but
court. Yeah.
it
It proves
it
up
actually
that there's a
I
relationship.
disagree. It does
Yeah.
go to the conflict of interest because if you've got somebody who is just as guilty as the people you're trying to put in jail, trying to prosecute them, you have to step aside. You have to step aside because it's going to come out.
Well, you should if you had any morals, but these people don't
No,
have any
ethics
morals.
require
So.
you to step aside because it hurts your
Well,
case.
we could probably debate
It hurts
that.
your case.
Well, but nobody's going to question the prosecutor about his ethical conduct in the trial, right? So the conflict of interest really is that she's getting personal benefit from the money that she's giving to him. But this is one thing we didn't pin down. What's the other conflict of interest because of the relationship? Right? Is it because her office couldn't handle the case and it's supposed to be independent? Because if she was having an affair with one of the lawyers in her office and her office was prosecuting the case, that's not a conflict of interest.
I go back to what Ship said. The conflict has to do with rewarding her lover with a hugely lucrative contract that becomes more lucrative the more defendants you name, the more complex the case is, the RICO versus a simple false statement case.
Right. So we're all on the same page with that, which is that the money, funneling money to him that she then benefits by because and sending it to him because he's her paramour, that's a conflict of interest. But the relationship itself is not a conflict per se, right? If he was her employee and not getting any money, it wouldn't make any difference, right?
Yeah, let's alter the facts a little. Just say he's just an employee. He's just a prosecutor in the
He's
office,
just a line
and
prosecutor, right?
and all she did was give him the plum assignment, but didn't create any kind of financial benefit in how he carries it out, as is the case with the contracts. These
Right.
contracts. If you look at the contracts, and I had written about them but never published, but they had like an annual cap. The contract. There's like 3 or 4 different contracts. I don't know that the last one was actually in evidence, but the first one was for like a 12-month period for $30,000 a month, so over 12 months. So it was capped at 360, and then he got an extension for like 8 months, and then he got another extension for like 10 months. So each one, I can't remember if each one went up a little bit, but I seem to think they did. So you know it calls into question, okay, is the continuing relationship responsible for him continually
The
getting
increases and
additional? Yeah,
right.
is the compensation, is the amount of compensation going up? Is the term of the contract being extended? Is any of that influenced by the personal relationship that is undisclosed?
Right.
That'd be a different thing if it was all above board and disclosed and everybody knew. That'd be one thing, but this is all hidden until
Well,
it's
what I haven't been able
unearthed.
to understand is why is it contracted out in the first place? Was there a finding that
Manpower issue. That's clearly what
okay.
she said. The office was insufficiently staffed. And actually, this came up today, King. Remember, there was a testimony about the contract actually just brought him in to work on corruption matters and not any specific case.
That's what the contract said. But there were two
Uh-huh.
other contracts that have raised questions in my mind, and I have not heard an answer yet. Both of his law partners had contracts too.
So she's funneling work to his firm because he's her boyfriend. Okay, this is a problem. But I'm trying to understand how the disqualification works then
One way
because
it could work is this cash business. If she and he are telling the truth about the cash reimbursements,
that's a big if, but
if they're
okay, yeah.
telling the truth, as I appreciate it was the firm, the 3-person firm, whose credit card he was using to pay the travel costs. Am I right or wrong, Chip?
It sounded that way. It sounded like it was his business credit card. Now, I didn't think make it super clear whether that meant it was a card that the firm was the backer on or it was just a personal credit card and he used it for
Well, let's
business,
assume.
right? So,
As I understood it, as I understood it, they were at one point he said they were actually listed as a partnership with the state of Georgia, but more recently they are simply 3 solo practitioners operating under a single banner,
But that wasn't the
and
case
that
when they first got this deal. And I don't
I'm
think
not
that was the
sure if.
case when they were traveling.
Right. In
hmm.
fact, if you look at some of his invoices, and I don't know if this came up today or not, but when I looked at the invoices, and there was the one of the first public commentaries about the invoice was billing for 24 hours in a single day. My first reaction was that's more than one person. And in fact, there are interests on that invoice that talk about the prosecution team doing
Hmm.
X, Y,
So,
Z. So
Together
my
some paralegals and associate probably and
or
right,
the three lawyers
so,
all
right.
billing an 8-hour day for 24
so
hours.
let's assume that it was a firm that was getting paid, the firm that was paying the expenses, and Nathan is being reimbursed in cash 100% of the expenses. He has just stolen money
Right,
from his
he might
partners.
be stealing money from his
He
firm.
absolutely.
Yeah, right. Right, that could certainly be. But it was seemed clear as mud to me whose credit card it actually was. And this is the problem with a lot of state court cases, folks, is that the record is really muddy. I clerked for a state court appellate judge, and the record would be really bad sometimes because people are totally not clear about what they're talking about. And
Well,
you don't have the
he testified that it was his card, his bank statements that he gave to his accountant to do his
right,
taxes with. She asked him extensively about whether he had ever used a card in the name of one of the other 2 lawyers, and he categorically denied it.
right. So does that
Never
make it
used
a
it.
business card or just his personal card? To me,
I
that's
think
his
it's
personal
it.
card.
No. I think it's his business card for his own solo practice, which was just like I don't think he called it a PC. I think like a professional corporation,
PC. Yeah.
or similar to maybe like an LLC in other states where it's really it's an association in fact, but the members are separate legal entities. That's how I heard him.
So,
That's what I understand him saying is my law practice is my law practice. I receive revenue because he said when they would get a check, they would split it up 3 ways.
Okay. So they're taking in the revenue separately, each of them.
Correct. The checks came to the firm, and then
Mhm.
the three individual lawyers divided and checks 3 ways.
Okay, if that's the case,
so he
then
can
we
have
we never heard of his share of his partner's money.
Yeah, I don't think it holds up, King. I think you're right. I think if they had separate contracts, the contract in his name was the one paying $30,000 a month. That's in his name. That's not in the name of if they had separate contracts, which is what I heard the testimony to be too, that they had their own separate contracts. What was the amount under those contracts, and how were they paid, and where did that money go? I did not hear that dealt with today.
I didn't either, and it's a big question mark for me. I blame the defense lawyers for not making that clear. Who got what and who paid what out of whose pocket.
Well, you can see where the trial judge might not be wild about getting into all of that.
Yeah, but I think it all got, as we all know, and I think we're getting to next, I think it all got sidetracked when he said, well, she would pay me back in cash. It's like, okay, we're now, we have just taken an off-ramp onto a different freeway.
Right, exactly. Yep. Okay. So
now, can I tell a brief war story on one of my this is like I'd only been in AOC like 4 or 5 years. A bankruptcy fraud case. I'll try to get through the facts fast. Bankruptcy fraud case. The defendant bankrupted his company to cheat his ex-wife out of any spousal support by bankrupting his company.
What a great guy. Yeah.
So miraculously though, just ahead of bankrupting his company, his sister buys a house that he then rents from his sister.
Mm-hmm.
The down payment on the house is $70,000. The sister doesn't have a pot to piss in, so where she came up with $70,000 becomes an interesting point in the bankruptcy fraud trial. Because my contention is it was his money, he gave it to her, she bought the house in her name, it actually belongs to him. He rented it, for a nominal amount for her. Blah blah blah. That was all part of the bankruptcy fraud that had many facets, but this was an interesting one. So as I'm going through all the paperwork, I realized that the deposit was $70,000, and that a month before she closed, she made a $70,000 cash deposit in her own bank account. And so the question is, where'd that $70,000 come from? Yeah, $70,000. She couldn't remember the source of the money. And then she couldn't remember that it was now this was like several years earlier. She couldn't remember that it was cash. She could not identify the transaction in any way in her memory. So I had kind of thinking this through, and I told the agent, I just had this moment. I told the agent, you know what? I went to my own bank. I took out $700 in $100 bills and $200 bills. And I took $698 ones and put a $100 bill on each side and put a rubber band around it. Okay. It's like 8 inches tall.
Okay.
I didn't use it in the trial. I had it in a box and used it in closing argument and just pulled it out of the box.
This is how it would look like.
And showed the jurors, would any of you have forgotten making a bank deposit that looked like this?
Right, that looked
the
like
jurors started laughing. That may have been one of my most ingenious little off-the-cuff things ever done in trial.
Right. It illuminates the point with the visual. Right.
So when I'm hearing this testimony today about she's giving them all these reimbursements in cash, it's like, this doesn't end well. This is not a gambit that they should have thought they could pull off.
I mean, seriously, how long did you spend working this story up together? Because if they went on trips, it's one thing if you're going out with your boo and you're getting dinner one night and he's getting it the next, right? Okay, but these are some serious trips. They went to Nepal, right? Okay, so she gave him $5,000 in cash for hotels and airplane tickets and stuff.
That was her testimony multiple times. I guess at one point somebody said they were going somewhere like every 2 months.
I mean, that's not believable on its face.
for a period, it was every month. But she tried to save herself by describing a hoard of cash she kept in her house all the time, because that's what her father had advised her to do for a safety net. All the time she had tax liens out. She owed money. She didn't have much coming in after her campaign. And then somewhere along the line, she dropped that, well, I had some money left over for my campaign, so that was the cash.
Yeah. Okay. I mean, just the complete devil may care way that she plopped that fact out was astonishing to me. Just, oh yeah, that's that, with no thought about whether or not maybe that's a problem actually. I wonder how many people decided to open up investigations on her today. What do we think
Yeah. State of Georgia, I think probably there's somebody in the AG's office that got a memo
right?
that said, track this testimony and then, start thinking about where this might go.
Is there
I,
a finance problem there? IRS would certainly seem to be interested, I would think.
well, no, part of her, wasn't just the campaign thing. That was one thing, but she also made comments, and
Yeah.
I think everybody can sort of imagine these kind of circumstances. You go to the ATM, you get 300, 400, 500, whatever. Yeah, and she would say she would take cash. When she would go buy groceries, she would take cash back, and
Right.
so you can imagine over time if you really. And I know people like this. I know people that just prefer to have several $1,000s cash available. Yeah, you want to go buy something
I
for
know
cash.
someone sitting at this table right here
Yeah,
with me.
yeah,
Me, myself, and I, who does
yeah.
that.
So it
But
happens. It happens. So I mean,
right.
it's not unheard of.
No, of course not.
But I think what we're going to see is we're maybe going to see some post testimony briefing where, based upon this testimony, the defense lawyers are going to go back and start totaling up how much that would have been.
Right. And see, that's what I'm saying. Okay, it's one thing to have a hoard of cash because you're afraid if there's a power outage and I need to go to the gas station and it doesn't work. But if you need cash for emergency purposes or you're a prepper, right? You got cash on hand. That's one thing. But once you start spending it, you have to keep either replenishing it, right? Or something else. So where's she getting all that cash from then?
Well, let's be fair in the sense that she is a single,
Person,
professional,
right?
six-figure income.
Right.
You would think she's got a modest amount of monthly expenses, so
Right.
she is
She should
going
be
to
able to save
accumulate.
some money.
So,
Right.
but
Yeah.
but the idea that the point you made is a good one. That if you are, 2,000, 3,000, 4,000 to reimburse this other individual for these, you're continually going to the bank saying, I need
Right.
another $5,000
Exactly.
in
On a
hundreds.
continuous basis. That doesn't make any sense. Yeah.
I want to add to that the issue that the judge articulated here. It's not only do you have an actual conflict, but whether there's an appearance of conflict. So,
Right.
appearance wise, you have boyfriend paying for all the trips with no documentation of any reimbursement. None. Just her word against the world. The judge could easily say that's an appearance of conflict.
Right. Because is the public just supposed to swallow that? That, oh, we're just going to take her word for it? I mean, some people would. Some people would say, well, she said that and there's no proof on the other side. Although, as I often have to remind people, the fact that there's no proof of the opposite doesn't prove the thing that you're trying to prove. um, but, you know, I don't understand how the question that Ship has identified hasn't come up more front and center because it would be one thing if it was a small amount of money, right? And she gave him this contract, and they were also going on trips, but it's a lot of money on these contracts. And so, uh, you know, why is there's just seem to be no thought and consideration given to the fact of this is an enormous case, and she's basically sweetheart dealed it to her boyfriend, and now they're trying to act like there's no problem there. I mean, I don't know, but I couldn't see the judge's reaction. So, King, what do you think? Is he leaning one way or the other? And this leads to people were asking this question a lot today. Why did he let her behave so badly on the witness stand?
Uh, he seems to be that type of judge.
He does.
From what I've observed in other hearings, he is very deferential to the lawyers. He puts up with a lot. He
Right. He's letting them try their
yeah
case,
yeah,
and he's doing his job. They're doing theirs, kind
and
of
he's
judge. Yeah.
smart. He knows his law, and he did emphasize that it's not only an actual conflict but appearance of conflict that he's going to look at. So
Hmm.
he maybe it's some deference to her uh, because she's the DA. He warned her a couple of times to cut it out, but
Right.
that's all he did. Uh,
He would have
Yeah,
done a lot more if there'd have been a jury, right? I think we all agree.
oh,
yeah, and I think the other thing that I think is at play here, and I don't know where I read this today, but he's up for reelection,
Is he?
and the time for opposition or for opposing candidates to file has not yet closed,
Okay.
and so I think they have under the same pool of voters,
Hmm.
and so it maybe I postulated today online that he's when a judge is already inclined to rule against somebody, to protect his record, he doesn't cut them off. Let them
Right.
say
You and I
whatever
were
they want.
both saying that he's
Get
letting
it.
her play like a fool because it's not helping her with him. He's going to let her put her nonsense on the record, and then he's going to rule how he's going to rule.
and
So,
and he's going to say, I let you say everything you wanted to say.
right.
I didn't cut you off.
Exactly.
I didn't limit you. I didn't stop you. And you made the best record you could make. So there's no basis to say, I
Right.
somehow, conducted an unfair proceeding with respect to you. So,
Right.
so I think that's part of it. But I also think he himself, knowing that this is being televised, when I think it's a great example of why trial proceedings should not be televised, because you get witnesses. She's not playing just to him; she's playing to the television.
Right.
I think that's a little bit maybe in the back of his mind, is that I'm not going to antagonize unnecessarily voters who are sympathetic to her. I'm going to let her have her say.
Right.
but because of that,
They had
he's
to.
not going to call her a liar. He's not going to find that she lied about the cash.
Do you think he's going to find that Wade lied?
He can easily find that Wade lied. Yes, as
But
on
maybe
his
he won't though. Really,
yeah,
right?
not as to the
Because at this point they've admitted the relationship, and
yeah yeah the Wade lied with the false filing in his divorce case. There's no way around that. As to the cash reimbursements, if he's any way politically inclined, he cannot find that Fannie and Wade lied about that.
was there any discussion about whether there was a lack of truthfulness in any of the pleadings before this judge? Wasn't there a declaration about their relationship? I wonder
Yeah,
if that was
the
problematic.
issue there is when did it start?
When did it start? Right.
Mhm.
Yeah, they both said it started after he signed his contract, shortly after, in early 2022. I think the contract was signed November 2021, and it started in early 2022. But the woman who testified first said no, that she was confident they were involved as early as 2019.
He could easily dodge that question with the appearance of conflict finding.
And
Right. I agree.
I agree, and I think that's why he has seeded his comments with that point. Is I think a good point that was made a few minutes ago was the idea that even taking at face value is true, the claim that cash reimbursements were made for her share of the travel expenses, not being able to document that in other way is creates a perception in the public's mind that there is something not right here, and on
Yeah.
that basis, and I think the other thing he could get to, I haven't heard anybody say this explicitly, and I don't know if he will, but he could certainly say, look, if this case is as factually justified and compelling as the Fulton County DA says it is, then why can't the Cobb County DA just as effectively prosecute it?
That's a
Okay.
great point. The strength of the case should not depend upon who's the prosecutor.
Which,
Right. Typically, it doesn't depend on that. Typically, it depends on the facts. So, well, the way the judge was letting her go on today, I think is problematic and is problematic for the system of justice, just eh, overall. I also think that it is not fair to the lawyer asking questions. A number of the responses that Fannie Willis gave were totally inappropriate responses for a witness. The witnesses don't get to question the lawyers. That's not how that works, right? You don't get to raise your own objections to the questions that you're being asked and pontificate the way that she was doing. And although I understand that a judge is maybe thinking, well, you can sit there and act like a fool if you want to, there's no jury in the box. And so I'm taking that all into account. But I think it does a disservice to the lawyers before the judge for the judges to tolerate that. I would not tolerate that if I were a judge.
If I were a judge, I agree with you 100%. But I've been in state courts. I've been before elected
Yep.
judges, and there are motivations, I'll call it, that lead to what you saw today. It
Right.
was not the best legal proceeding, but from an entertainment standpoint, it was fascinating.
It was fascinating. Yeah, I know. Well, state court is where the entertainment is at. The federal courts are boring by contrast, for sure. So I had a case years ago in a rural county in Maryland where my client had been indicted basically for accusing he was representing some citizens on a claim against a local professional, and this local professional happened to be a friend of the district attorney. They don't call them that in Maryland, they're called state's attorneys. But this guy happened to be friends with the state's attorney, and so he didn't like getting this letter from this lawyer. It was a settlement demand, right? Pre-filing settlement demand. So he went to his buddy, the Commonwealth state's attorney, and said, this lawyer's haranguing me. And so the state's attorney indicted the lawyer for extortion for sending a pre-trial settlement demand. And the lawyer was well liked by the judges in this community, but no lawyer in that county would defend this lawyer in this criminal case, in this totally trumped up, ridiculous charge. So I had been on the other side of a case against this lawyer, and he came to me and said, "Hey, remember me? We had this case years ago. Will you defend me?" So I said, "Sure." So I went down to defend him, and it was totally just personal bias. The prosecutor literally just didn't like it that this lawyer was making a demand on this other guy. So I filed. There's good law on this in Maryland on this conflict question. So I filed a motion. We went down. We were having a hearing, and the office defended the charge. And we started having a hearing, and the judge, who was an old, very experienced judge, he sat up there and he listened to the opening statements. And um, after he listened to both sides' opening statements, he said, "Well, I think we're going to take a break now and go and have some lunch. And then when we get back, let's see if it really still makes sense to put on any evidence in this case. And this was basically him telling the other side, you don't, she's got you dead to rights. You don't want her to start calling witnesses, right? So, but they didn't take the hint. So we went to lunch. I tried to work it out with them. That didn't work. So we come back after lunch and I'm getting ready to call my first witness. And the judge is like, wait a minute, we're calling witnesses? And I said, well, Your Honor, I couldn't work it out with them. So he said, counsel, come back into chambers with me. So we all trooped back into chambers. We get back there, and the judge starts talking about how the Baltimore Orioles are doing this year and how nice the weather's been and all of this stuff, right? I'm waiting to see where he's going with this. Finally, he gets around to talking to these two idiots, and he says to them, you don't want me to rule on her motion. You don't even want me to let her put on evidence. So here's what we're going to do. We're going to go back out there in 5 minutes, and you're going to announce that you have decided that in the interest of public transparency, you're going to ask the state attorney general, whose office is in Baltimore, to come in on this case and take it over from your office. And they were like, we are? And he was like, yeah, I think that's what we're going to do. So we went back out onto the record, and that's what they had announced, to the judge, like it was all their own idea, that that's what they were going to do. And so I'm looking at this case in Georgia thinking, this is how this goes in state court sometimes, right? It's just local people doing stuff that they have no business doing, that don't follow any of the rules. And every judge in the courthouse I was in had recused themselves from that case. So it was a judge from another county had to come because they were all afraid to stand up to this prosecutor. Every single lawyer, every single judge in that courthouse. And after the hearing ended, a bunch of local lawyers came up to me, because I wasn't from that county either, came up to me and said, thank you for taking this case, because, we were all just like, we're all terrorized by this state's attorney down here. So I was looking at this today thinking, this looks very familiar to me. But it was object lesson, I think, for the nation to see, elected local prosecutor can be a problem.
Well, and then now combine her presence, her agitation, her mannerism. Combine that with the grand jury foreperson who we saw,
right?
The grand jury foreperson who gave the interview, and then think to yourself, so these are the two leading lights behind the decision to indict the former president.
Yeah, this is justice in the courts here. Okay. Yeah, it's totally not. Well, all right, King. What's going to happen now? Start again tomorrow at 9?
Tomorrow at 9. The only witness I know of who's coming is Fani's father. I expect he's going to talk about cash stashed away.
How he told her, be sure you always keep $32,000 in your.
And I think the lawyers are gathering together to get together to put together a package or a summary of payments, bills. That's the financial part of this. Beyond that, I'm not sure who we're going to hear from.
Then you'll get some closing arguments.
I will say this: I've noticed in the briefs that were filed that the state is citing and emphasizing case law that says it's not a conflict if there's no financial interest in a conviction. And they said, no matter who you believe here, Judge, there's no financial interest in a conviction. My argument against that, if I were defending it, and I haven't seen this written anywhere, but it may come, would be this. That conviction rule is really broader, and the true statement of the rule is a financial interest in the outcome of any proceeding.
Well, that seems like old case law that probably relates to like bribing prosecutors,
Right.
right?
That
Um,
that yes, but here there's another element. You have two grand jury proceedings, and as Ship pointed out earlier, the outcome of each of them was more and more complex, more and more defendants, more and
mhm.
more novel legal theories to prosecute somebody. So, to the extent
It
that
just seems
both
to me
both
it's a.
Fani
Oh, go
and
ahead.
her boyfriend were motivated financially to keep this thing bigger and longer.
Right, that's my point. Is that this is a different kind of conflict than the kind of conflict that that case law is talking about.
But it is an outcome driven conflict. Both of them had a conflict during the grand jury.
Right, I agree. I think we're saying the same thing, kind of a different way. You're saying the broader rule is more like, your interest is in how the thing comes out in a financial sense. Do you benefit from that financially, from the outcome? But it's the different way of saying the same thing I'm saying, which is, okay, it's a different version of the kind of larger rule. That doesn't mean, if there's two different kinds of apples in the basket, that doesn't make them both mean they're not both apples. So, but you see that a lot in state court too. There's very specific case law that doesn't apply to your situation, but the other side will cite it like, well, this is the only case law that applies. Oh, okay, but that's not the kind of case we're working on.
There's
Well,
another. I would be curious if anybody's ever thought, or even the judge would even consider allowing him to go down this road. But did the two of them ever discuss the possible assignment of rights that might follow a conviction, and how much they might make from writing a book or having a movie portray them? And if they were a couple, they would share in that money.
Uh, I don't know about that, but there's something on the table that's not hypothetical. There's a book just came out a week or two ago. Uh, One of the authors is Michael Isikoff of Russia,
Yeah, I saw that.
and according to the publisher's blurb, uh, Fani and her prosecution team sat for hours, literally hours of interviews, including discussion of what happened in the grand jury. And I can't imagine that nobody said the word Trump is guilty. Trump the facts show Trump did X, uh, all of which are prohibited by lawyers' ethics rules. There's specific rules applicable to prosecutors, general rules applicable to all lawyers in a pretrial setting, that you cannot say things pretrial that might sway the jury uh, against uh, or in favor of your client, and you cannot, if you're a prosecutor, say things to indicate the defendant is guilty. That's why when you see statements by prosecutors announcing indictments, they always say he's presumed innocent until proven guilty.
yeah, a lot of the rules require that disclaimer on it. I personally think that in all four of the former president's cases, the prosecutors have broken those rules. They clearly are going beyond simple descriptions of the case, right? The kinds of things that the rules allow prosecutors to do so that the public is informed about criminal cases. I think they've gone way beyond it in all four cases: the DC case, the Florida case, the New York case, and the Georgia
I I,
case. And
I,
it's
I
just,
agree with that, but from what I'm reading about this book, the Georgia prosecutors have launched into the stratosphere a
yeah.
violation.
Well, maybe she'll get a bar complaint filed against her too, in addition to everybody wanting to know about her cash payments. But good grief. So no ruling from the judge tomorrow, you're thinking. Hey, King.
No, he said he's not going to rule tomorrow. He'll take it under advisement and I guess write something.
I
Well, what
think
do we
I
think?
think he might. I think he might ask for some additional briefing based upon the
Briefing.
testimony as received.
Right. I think so too. But which way do we think he's leaning, or which way do we think the evidence goes? What do we think he'll do?
I a couple of nights ago when we first talked about this Spaces tonight being on this subject, I confessed at that point that I hadn't followed it closely enough. I haven't read the briefing. I don't know what the legal standards are. I was only entertained by what I listened to
Yeah.
today,
Yeah.
and that's about it. So I'm reluctant to opine as to where I think the evidence got them against the legal standard that applies.
Okay. King, what do you think? You saw all of
I
it, I think,
saw it
today,
all
huh?
today, and I've read the briefs. The uh, the judge is going to have a hard time politically and just professionally say this person lied and that person didn't, because
Right.
it's kind of a flip of the coin situation. Uh, on the other hand, it's the appearance of conflict issue that's going to be most troubling for him. How he comes out, I
Okay.
can't say, but he can come in. He can easily. I can see him entering a disqualification order uh, because of the appearance. On the other hand, he can do a whitewash and probably get him some
Hmm.
votes next election.
So I
Yeah,
think Trump.
the thing he could do tactically is if he does not want this, he could leave her on the case and simply not let the case get to trial before the election.
Well, yeah, he could do that, but why would he? You're saying you think he would do that in light of this development, just to see if Trump gets elected or not, and then
Well, it would
what she's
blunt
trying to do.
it,
Yeah.
yeah,
Right.
it would prevent her from accomplishing what she is trying to accomplish without essentially killing the case.
Right.
On that
Well,
issue,
I
let me weigh in. I think the chances are very remote this case gets tried before the election. There are some still pending uh, uh, petitions for the 11th Circuit to hear en
right
banc the uh, removal
removal.
filed by Meadows and Clark. I've read
Right.
Clark's brief. It is it's solid. It will be hard for that court or the Supreme Court if it goes that way uh, to say there's no grounds for removal. Uh,
Right.
and,
I've thought that the whole time too.
and Clark has filed a removal, immunity argument to dismiss the case against him before this judge. And this judge has piled up a pretty large stack of demurrers, which is basically a motion to dismiss, and the immunity argument that Clark has raised that's going to tie up this court in legal
Mm,
hearings for a while.
a
And
while.
Fani wants to start trying this in August. I don't see any way they can start picking a jury in August.
Well, I'm wondering if Trump's lawyers in the Supreme Court shouldn't get a transcript of this hearing today and send it to the Supreme Court justices and say, this is why presidents need to be immune. Because this is what happens. Exhibit A.
That's a
You
good
got
point.
you got lunatic local prosecutors who will go after him. It's
Yes.
insane.
Don't send him the
Well,
transcript. Send him the friggin' video.
yeah, that's true. Right. Right. I mean,
And
that would
because remember, and we didn't talk about this too much the other night. This was part of the panel's justification for not needing immunity because there
right.
are there are limits. There are
Right?
ethical
Yeah.
considerations that
Everybody's gonna
prosecutors,
act like grown-ups.
there are
No, they're not.
grand jury requirements to get an indictment. So there's
Professional
lots of
prosecutors. Right.
safeguards in place to prevent a rogue prosecutor from doing what the Trump claims a rogue prosecutor could do.
Right.
Can we talk about the two filings that have happened in the last 2 days? Did everybody
Yeah,
see that Trump's team
we might as
responded today?
well. Yep, we might as well.
Yes.
So let me tell
Yeah,
folks what happened. So yesterday, the special counsel's office, they had until next Tuesday, but they didn't take their time, and they filed in the Supreme Court a pleading saying, "Oh, you should not stay the case. There's no reason for the trial not to keep going in front of Judge Chutkin in the district court in D.C."
they shouldn't
And
they shouldn't grant cert. Not that they just shouldn't stay it. They
I
shouldn't
know,
even consider
I know.
taking it.
He hasn't even filed asking for the cert yet. I mean, it's just preposterous. So, and then Trump's lawyers filed um, their basically reply back, right? And so, Ship, what did you make of these two pleadings?
Well, I only was able to scan them, and if you follow me on Twitter, you saw that
Mm-hmm.
yesterday I posted a link to what I thought was a quite astonishing column written by Jack Goldsmith, who I hold in
Yeah.
very high regard.
Yeah.
The guy's got just a gold-plated DOJ pedigree.
Right.
He was the director of the Office of OLC, Office of Legal Counsel, during the Bush administration. Had been tasked by presidents or attorney generals from both parties to do difficult projects, and had always been
Right.
well received by Congress. And he's no fan of Trump. He's hooked up with the lawfare guys. Although he's not formally a member, I think he just
Mm-hmm.
he's not quite in their camp. But
Right.
he is not a fan of the prospect of a second Trump term.
Right.
But he just came right out and said, "Look, Jack Smith can't come right out and say it, but he wants a trial ahead of the election to influence the outcome of the election."
Right.
And that is contrary
That is
to
what
a
is going on. No
DOJ
one is
policy.
saying right. That no one is saying that's what it is, but that's obviously what it is.
Right, and he basically said it's unseemly and it's unworthy of the Justice Department, and the Justice Department should put a stop to it. Merrick Garland should tell Jack Smith, you cannot do this. It doesn't matter whether you think you are positively affecting the election or negatively affecting the election. You cannot take any step which will benefit or work to the detriment of one candidate or the other. We don't do it. And so what I saw today, and I put this up if you haven't seen it, within the first 3 paragraphs of the Trump reply today, they're quoting Jack Goldsmith's article from yesterday.
His article. Yeah, right.
And I said today, now, I mean, this is my view. My impression is Jack Goldsmith is taken as a serious thinker in the D.C. legal community, including at the Supreme Court. He's a professor at Harvard now. He's
like a lawyer's lawyer. He's like, this is what the law is.
All the justices know him.
Right.
When he comes out and puts it that bluntly, look, it's transparent what you are doing. It doesn't matter that you won't admit it. Nobody should be mistaken.
Right. It's what we started from, on the point you started with, which I always tell my clients too. You can't deny things that everyone can see with their own eyes is what is going on.
Except
this does not help.
Except that Smith did not deny it. He just ignored it.
Right. He just won't come out and say it. He's pretending.
And he won't give reasons why the government,
the
quote,
public interest
has a right to a speedy trial.
Right. Yeah. I don't like that articulation. I don't think that's accurate, actually.
Well, and then today, or in his brief yesterday, I can't quote the line, I don't have it in front of me, but he made reference to the government having an interest in an expeditious trial. It's like,
right.
How does the government have an interest?
Right. The public might, but the government doesn't.
Right.
Right.
And when he talks about when he talks about the government, he's not talking about the court, and he's not
Right.
talking about the Congress.
Right.
He's talking about the Biden administration, which is the prosecutorial entity. It is the executive branch.
Right. His whole pleading reads like he gets to make all the decisions, and these Supreme Court people just really need to get out of his way.
Oh, and that that's what I loved, that it would not be in the public interest to
Right.
grant cert or delay the
For
case.
the
It's like,
Supreme Court to decide that, yeah,
so you're
okay.
telling us that if we disagree with you, we are not acting in the public interest.
Right, I know.
Who
Right.
the hell are you?
That's what my response to his whole pleading was. Who the hell are
Well,
you to make
actually,
this? Good grief.
that argument turns on its head when you consider how is the public interest expressed. It's expressed in elections. So he's telling us we have to do something to shortstop somebody getting elected. That's
Right.
not going to fly with
No.
the Supreme Court.
No.
Yeah, I think it's almost like there's no self-awareness in the people that are signing those briefs. And it's funny because signed as counsel on that brief is Michael Dreeben. And
Yeah.
I would have never expected Dreeben to crawl that far out on a limb. Now, maybe it was put to him, no, that's got to be in there. But what I think was also not lost on the audience for that brief, meaning the justices, what I think is also not lost upon them is that Jack Smith has a history of not respecting the barriers. He just kicks them over and goes through them.
Right.
He showed that without question in the way he prosecuted the Virginia governor.
Right. McDonnell. Yeah. Yeah, I know. And the whole thing reads that way. I'll be surprised if some of them wouldn't take a little bit of offense at this.
Oh, absolutely.
You're telling us how to do our job. Oh, no one's asking you.
Right. Didn't you tell us a month ago that only we could resolve this question?
And he doesn't even bother to address that disconnect, right? That dissonance. That just astonishes me. The government has to do better than that. The courts should expect more from them than that.
But this is what happens, and I'm not saying it's not needed. This is what happens when you give one megalomaniac the authority to do what he wants to do, and the only break is somebody who currently is not really doing his job, which is Merrick Garland.
Right.
Merrick Garland is a figurehead. The person running that department is Lisa Monaco.
Well, I think it's also not a good look when you didn't even take the 6 days that they gave you to file. You filed the next day.
Well, I think part of it, they had it in the can. I don't think they would have had to wait to see what Trump was going to file to be prepared. But it's almost like, hurry up. See, we're going fast. Exactly. You should go fast too.
Right, exactly.
And then have commentators like Roger Parloff on Twitter create these ridiculous time frames.
Did you see that timeline?
And it's like, hold on. My response to it was, hold on. Explain to me what would motivate the court to cut itself off from full briefing on a novel question of law that only the court can really decide. Why would they cut themselves off from full briefing? And then why would they give themselves only 10 days to prepare, them and their clerks to prepare for oral argument?
Right. Right. His whole thing reads like, I used to have to tell some of my clients, look, just because you want that doesn't mean we're going to get it from the other side. Well, but that's what I need. They should want to do that. No, they don't have to want to do the stuff that helps you. That's not what motivates other people. Good grief. I loved his thing too because he has like the jury coming back in September and then the elections in November. And I was like, okay, so obviously he's assuming that Trump would get convicted. But if Trump gets convicted in Judge Chutkan's courtroom in September, he's not going to sentence him until January.
Right.
So Where's that on your little timeline?
Yeah, except he doesn't need a sentence. He may not even need a conviction. He may just want and be angling for at least a week or two of headlines about what his case is. That's
Oh,
You're
I
talking about
think no,
Smith.
no, I think he
Yeah, we're
wants the
talking about
conviction.
Parloff. Yeah,
Uh,
right.
no, I think Smith wants the
oh
conviction.
no,
He thinks the
Yeah.
conviction is the kill
oh yeah,
shot. But but
that's
but
100 on the scale. But
yeah.
he'll take a 60 or 70 if he can get uh,
Oh,
2 weeks worth of
well,
headlines before the election of his case without any
well,
defense.
I guarantee you, I know what they'll
Right.
do now. If they are able to get started 10 weeks, 12 weeks before election day, they will truncate the case because
Oh, wow.
the verdict is
Absolutely.
foregone.
Yeah,
The verdict's going to be
right,
guilty. There's no
right.
question about it. It doesn't matter what the evidence is. Look, I've sat through jury trials. The jurors are impervious to anything contrary to what the government presents
Right. To the
in that
government's
district.
narrative on January 6th. That's
Exactly.
all. Yeah.
It's not even there's not even open to the suggestion that they will consider anything. So the outcome is so he is going to race to finish his case in chief and then use every tactic he can employ to shortcut a defense case just so he can get to the verdict because he knows what the verdict will be and he knows it'll be fast.
Right. There won't be long deliberations by the jury. No, I agree. Well, as we've talked about many times now, I don't think that trial's happening
I
before
don't
the
think so either.
election. Yeah, so
Uh,
he can
uh,
want whatever he wants, but Parloff is just insane on his timelines.
yeah, Parloff was famous because I was watching it at the time during the first Oathkeeper trial for blogging live the events of the day. And then when I talked to the defense lawyers later on, they would say, yeah, but on cross examination, we got the witness to say X, Y,
Right,
Z. And none
right.
of that was in Parloff's,
None of it was on his
tweeting.
timeline. Yeah, nice. Honest reporter there. That's what we need. Okay, well, I don't know if there'll be as many fireworks tomorrow, but King, you're definitely going to watch, right?
I'll be there with my barrel of coffee. And yes,
Yeah. So for people who've asked the questions, this judge, if there's a trial, is definitely not going to let witnesses in front of a jury act that way. He's not going to give the former president leeway to pontificate about stuff that he wants and let them argue with lawyers. So the performance by that district attorney today, it was a discredit to her office. Lawyers should not act that way from the witness stand, and in general, they don't. Although, as I was saying on Twitter, lawyers are invariably very bad witnesses, I will say.
I've had them as witnesses, and lawyers are absolutely the worst. You cannot shut them up.
Yeah, they won't answer the question. But judges are worse. Judges are the worst clients to have and the worst witnesses to have. I'm sorry to say, but it's the truth. All right, guys. Well, I think enough for tonight. King, if something really dramatic happens tomorrow, we can go again. So let me know what you think. I'm sure people will be interested in maybe a shorter one on a Friday night.
Deal.
Shorter?
Yeah, shorter.
Why?
Playoffs. Playoffs. You guys got any final thoughts?
Not for tonight.
Yeah, not for
I'd be curious
Okay.
about a poll as to what was more entertaining, today's hearing or Judge Judy.
Well, yeah, some of us on this call, and I think you are included, King, remember the original People's Court with what was his name,
Oh,
Judge
yeah.
Wapner.
Yeah, Judge Wapner. That's
They're
right.
all they're all impersonators of Judge Wapner.
That's true. God, I haven't thought about that for years. When I was in law school, we watched Court TV, which was really actually pretty interesting. And Dan Abrams, is it Abrams?
Yeah, yeah.
Was on that. He was actually good then. He seems like a bit of a not not quite the same now, but you could actually learn quite a lot, I thought, from watching the actual live proceedings. So I
Uh,
think having cameras in the courtroom is not necessarily bad, but you can see from today why the courts are so scared of it in federal court.
all right. Had
Okay.
fun. Look
All
forward to
right,
next time.
guys. All right, talk later.
All
Bye.
right. Bye.
Good night,
Good night.
everyone. So, you guys, my cheeks hurt from laughing so much today and yesterday about this crazy case in Georgia. So, I cannot wait to find out from Kingmaker what exactly happened. Kingmaker, can you hear me? Unmute me.
Yes, I can.
Yeah, I think
Right.
you're the only one of the group of us that that sat through most, if not all of it. Did you watch the whole hearing today?
Yes, I did.
Oh, good, 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 good. Okay, so Ship and I were dipping in and out, and Aaron, I think you were also dipping in and out. Did you watch any of it, or were you just following it?
I watched some of it, but I mostly was following everyone else.
Right, yeah, okay. All right, so let me make some introductions here. I think most people who follow me and have done some of the spaces know that who Kingmaker is, but just in case there's new folks, and since we have a new speaker tonight, let me do a quick intro. So I'm a lawyer, obviously, and Kingmaker's a lawyer, and Aaron is not a lawyer. He was an agent. You're an armed agent, right, Aaron, for IRS?
Yes, I was a special agent with the IRS Criminal Investigation.
Right. Okay. And you're retired now from the government, right?
Right.
Okay. So the three of us are retired. Ship is not retired. He's working hard on those J6 cases. Um, and he, as everyone I think knows, but if you haven't met Ship yet, he's a longtime prosecutor now, quite a long period of time. Not as long, maybe half as long, 10 years, I think. He's been a defense lawyer and he's defending a good number of the J6 cases here in DC, although he's actually himself from he lives in Hawaii and was a prosecutor for quite a while, both in Hawaii and in California, in the federal system. So I was a criminal defense lawyer. Before I was a lawyer, I was a special agent doing background investigations for security clearances for a few years with Department of Defense. So I was also a special agent, but not an armed agent. And Kingmaker has been practicing, is it almost 50 years, Kingmaker?
I've been a lawyer for over 50 years. I retired about 5 years ago. Uh, Dabbled in it since then, but
Aha.
full time before that.
Right, exactly. Okay. And then I practiced law for 26 or 27 years and have recently pretty much retired. I still give advice, but I don't take cases in court anymore. Um, and we may or may not be joined by my husband, who's also a lawyer. He was a longtime federal prosecutor, 10 years, and he's been a defense lawyer now for, I think, almost 40. He's been practicing almost 50 years. He's actually working on a brief upstairs right now. So he may come down and join us later. We'll see. All right. So tonight we wanted to talk about day two, part deux, of this crazy hearing today. And King, I mean, I thought it couldn't get any crazier than yesterday, but I think today might have topped it.
Today was wonderful, and for many reasons, including legal nerds like me.
Right. Yes, there were a lot of legal issues today. It reminds me when I was in law school, the first year I was in law school, was it the first year? No, I think it was the second year. Yeah, because you had to, at Georgetown Law, you only had to take evidence as an elective. It wasn't required, which I thought was dumb then and I think is even dumber now. But anyway, I took evidence because I knew I wanted to be an in court lawyer. And that year was the year of the O.J. Simpson trial. And so we spent a semester studying evidence, and we basically just used the O.J. Simpson trial, the professor did, as the basis for teaching all of the evidence rules. Because my God, I think they used every rule in the book in that case. So this had a similar feel to it today, Kingmaker. What do you think?
It did. It really did. Parts of it.
Yeah.
Other parts of it just were took me back to some old trials I had.
Yeah. Yes, so it can get wild and crazy in state court because people just do unexpected things. I mean, you would not believe the stuff you see in local, and especially criminal courts. It can be pretty amazing. So, one of the questions people had was why was Fannie Willis's dad allowed to be like prepped with her there, and was had Fanny watched the testimony of Wade from yesterday and those kind of things. So just so people know, there's something called what lawyers call the rule on witnesses. And this is it's not kind of in the rule book per se, but it's called a rule. It's what lawyers call it. And pretty much in state court, it's not like it always applies in well, federal court either, as I think about it. Usually what happens is one of the lawyers in the case, quote unquote, invokes the rule on witnesses. The lawyer will say, Your Honor, I'd like to invoke the rule on witnesses. And the judge will say, Oh, yes, oh, yes. So identify yourself, raise your hand if you're a witness in this case. And then they make all the witnesses get up and leave out of the courtroom if they're there in the courtroom, and they're not supposed to talk to each other about their testimony, and they're not supposed to listen to the testimony of other people testifying. Now, how the judges think they're actually policing that, since they make all the witnesses leave and therefore they don't have control over them anymore, I've never been able to understand. But it's from the old days where, there was no audio feed from the courtroom. It wasn't like it was being piped into another courtroom or on TV. And so if you excluded the witnesses from the courtroom, then they couldn't hear the testimony of the other witnesses. But of course, that's not the world that we live in anymore. And so now you have this situation where the if you invoke the rule on witnesses, the witnesses all leave, and then kind of perversely, the judge loses control rather than having control over those witnesses. So, Kingmaker, did anyone invoke that rule yesterday or today that you heard?
Yesterday they did, yes.
Okay.
Miss
Who
Merchant
invoked it? The defense or
invoked
the government?
the defense invoked the rule,
Okay.
and the judge ordered all witnesses, anybody who'd been subpoenaed or expected to testify, to leave the courtroom, not talk to any other witness, don't talk about the case with anybody, don't, basically shield yourself from all information about what's going on in the courtroom. I'll say that in the old days, back in the day, courts really took this seriously.
Yes.
And some would go so far as to send witnesses to a room in the courtroom
In
where
the courthouse. In the
in the
courthouse.
courthouse
Yeah.
rather,
Yeah.
where they couldn't see anybody else, couldn't talk to anybody else. They were allowed to talk to the lawyers, but the lawyers were under strict orders by the court to enforce the rule.
Right, and
That
lawyers
is,
did that. It was a rule. You're an officer of the court. You were supposed to tell your witnesses and did. You can't talk to each other, right? So, but those
but
days
it
are
was
kind of
clear.
gone, don't you think?
Yeah, it was clear yesterday that Fani Willis had not followed that rule
Because
because
she'd been
she
watching
came in.
Wade's testimony, right?
Yeah, she came in
Hot. She
raging
came in
mad
hot.
about things that had been said.
Right.
That she mysteriously, gathered from the airways or ESP or something. But it was clear she knew what had happened because she was mad at certain people
Right.
about what they had said about
Right.
her. Uh,
Now, his name is not Willis. Her father's name is Floyd. His last name is Floyd. Am I right?
Floyd is actually the third Floyd in the case.
Oh,
Did
good
you know
grief.
that?
No.
Yes. One of the defendants is Harrison Floyd,
Okay.
a uh,
One
a
of the
Trump
lawyers is a
person.
Floyd too.
Yeah, there's a Floyd who's a lawyer in the
Okay.
case.
Now we got a
Uh,
witness who's a Floyd too. All
now
right.
we have a
Fabulous.
witness who's a Floyd.
All right. Well, I may call him Daddy Floyd then.
Yeah,
So, or we could call him her father, whatever. So, all right. He wasn't there when the rule on witnesses got invoked, though, right? So, I wonder who the lawyers are supposed to communicate that to all witnesses, right?
the lawyers are told early on to communicate that to all the witnesses and to make sure they understand it and it's enforced.
Okay, and that didn't happen because, in this case, because it seems like, is this right, that Fanny was sitting in on the prep session with him, with her father last night? King, is that right?
Yes, he testified that not only that happened, she sat in on the prep session, but he watched the news and saw excerpts of the trial.
Okay.
And he's a lawyer, so he knows
Yeah.
better.
Right. He does know better. Yeah. He should. That's something that maybe a lay witness wouldn't know, but a lawyer, knowing they were going to testify, should have enough sense to not watch excerpts of the trial the day before. Did the judge do anything about that, though?
The judge didn't do anything, but he said something. He said, I may take,
Oh,
he
King, we
didn't say
lost
would, he
you.
said,
I
I
can't
may
hear
take
you.
that violation of the rule in consideration
Oh no.
in
King, can you hear
assessing.
me?
I can hear both of you.
Yeah, yeah.
Oh, okay. All right, King, you're back now. Yeah.
Okay.
You
Yeah,
said the judge didn't do anything, and then I lost you. What'd you say?
he the judge said, uh, I may take your violation of the rule in consideration in assessing credibility.
Right. Well, I mean, there's not much else a judge can do, right? He can't make him unhear the testimony. He could strike his testimony for a willful violation of the rule on against witnesses, of the rule on witnesses. But have you ever seen a judge do that, actually?
I've seen one, yes.
Hmm. Yeah. I actually, as I'm remembering it, I had a judge in the Eastern District of Virginia try to do that to me one time because a character witness that I wanted to call came into the courtroom after we'd started and I didn't see him come in because your back is to the audience when you're talking to the judge. Um, and in that case, I will say to his credit, the federal prosecutor in that case helped me out there and he didn't press the point. He didn't object. He said, look, she didn't see him come in and he's a character witness. We don't object to this witness testifying, even though the rule had been invoked. So, but other than that, right, it's rare for a judge to really be able to do anything about it. The lawyers are really supposed to police it because it goes to the integrity of the testimony, right?
Yes, I'll say that, but the rule only takes effect when the trial starts.
Right.
You can sit down. The lawyer can gather a whole room full of witnesses ahead of trial and
Right.
talk to all of them if he wants to. So, and they can compare notes. They can talk to each other. There's no rule against that.
Now, if you do that too much, though, prosecutors often take the view that that's obstruction of their case.
Uh,
So that's a problem.
a lawyer has to police it, but
Right.
it happens. I can
Right.
assure you it. Witnesses do talk to each other. Sometimes with the lawyers being there, sometimes against the lawyer's advice, but they do talk.
Right.
But that doesn't violate any rule when they do that, so long as they're not, shaping testimony and getting one to lie, that sort of thing.
Right. Right. All right. So that was one rule that got invoked. And then again, it's kind of started with a rocky start today, it looked to me like. This is often the case in state court, I will say, right? Not so much in federal court, but in state court. The people haven't cleared security at the courthouse. They're not there in the courtroom. They're in the wrong courtroom, right? It's just a little bumpier. And my experience was state court judges are a little more forgiving of maybe there was a traffic issue getting to the courthouse, something going on, right? But this is second day of this proceeding, and both days they haven't been ready to go at go time, right?
Uh, that's true, but once it got started, it was very entertaining because those first two witnesses, were just wonderful, both of them.
They had some stuff to say. Yes, they did.
Well,
Well, so my
I'm talking
question,
about real characters.
yes, that's true. That's true. But my question is, how did it develop that the Bradley, the partner, Wade's partner, that he wasn't going to be there or he was going to be late? Did they tell the judge this morning that he had this doctor's appointment? How did that unfold?
Uh, when they showed up, they said he was at a doctor's appointment, and he'd come over as soon as he's finished.
Okay.
And that they've repeated that message all morning. And the judge got very irritated and chewed him out when he got there
Did he? I didn't
in
hear
the
that.
afternoon. Yes, yes, he did. He said, "You're under subpoena. Nobody told me about any doctor's appointment," and uh, just indicated his intense displeasure for the
Displeasure.
way. Yes, because the lawyer was. I mean, the witness was a lawyer
Right.
and knows better.
Right. Now, if it's an emergency, you have to go to the doctor. But and the judge will usually wait to see does that prove out, right? But hmm. So
This was not an emergency. This
oh
was
yeah,
a
yeah.
scheduled doctor's appointment.
And see, the court should be notified of that ahead of time. Of course, he probably thought he was going to finish testifying yesterday, right?
Yes, he was called to the stand yesterday. I guess he assumed he'd be done,
Right.
but nobody bothered to tell the judge, "Oh, by the way, he's got a doctor's appointment tomorrow that
And
could
that's
take
not good
half the
practice.
day." Yeah.
Right. That's not good practice. If the witness carries over and you weren't expecting that and they have something like that, you have to tell the judge before the close of the proceeding on the day that you're on, which was yesterday. You don't show up in the morning and say, "Oh, by the way, judge, my client's not going to be here." That doesn't usually go over very well.
And by the way, he was really neither side's witness.
Hmm.
The defense wanted to call him and get stuff out of him that he claimed privilege on, and explore what he knew that wasn't privileged. The prosecution wanted no part of him, but they didn't want him to be there at all. So he was kind of adverse to both sides.
Okay. But the
So he,
defense had subpoenaed him, right?
yes, and he had his own lawyer there. His own lawyer was at fault for not telling the judge.
Exactly. That's what I'm saying. It wasn't that was not the witness's fault. That's his lawyer's fault. That he should have done better vis-a-vis both his client and the court there. Okay. So, but Mr. Bradley, he did testify, but in the afternoon, right?
Yes, he was all afternoon,
Okay.
and it was that it was interesting testimony and a case for legal nerds
Right.
like me.
So we'll get to him. So all right, so in the morning, he's on hold. The judge isn't happy about that. So they went ahead with another witness, but it was hard for me to follow from the reporting exactly what was going on. Did the defense end their part of their case except for Bradley?
Yes,
Okay.
yes.
And when did they do that? This morning?
They well, they said that we still have Bradley to go, so they never ended their case
They didn't technically
until he
close.
took the stand.
Right.
So the state uh, went out of order, so to speak, and called their first witness, who was delightful.
Right. All right. So tell us about that.
Is its former governor uh, Roy Barnes. He was governor back in the late 1990s, I think, early 2000s. He
Okay.
he was your prototypical deep
Politician?
deep Georgia Southern drawl politician slash trial lawyer,
Okay.
and he played the part perfectly.
And so the government called him, but for what purpose?
Um, I'm trying to remember. He didn't have much to add. He
That's what I thought. Yeah.
he was just entertaining.
Right.
Uh, he he was the person that Fani Willis first went to to take over or to lead the Trump prosecution.
Oh, I see. So this
So
is going to, she didn't just steer this to her boy toy. She tried to get a real person to do it first.
a real trial lawyer. I mean, a excellent trial lawyer with a huge reputation
Right.
and well loved by a large part of Georgia.
Okay.
And if anybody outside of Georgia watched him, they'd love him too.
Okay.
He's just one of these lovable lawyers slash politicians.
Right.
That's
Avuncular type. Okay.
yes.
Yeah. And he turned it down? Is that what happened?
He turned it down. He said I've been I think he said yeah, I had the case once uh, where I had to have bodyguards,
Mm.
and I didn't want any more of that.
Been there,
I,
done that.
I
Okay.
bet no more, thank you. Uh,
Okay. Well, so that's a good point of proof for them as far as it goes, but it doesn't really prove that she didn't give this contract to her boyfriend with in an improper way
yeah,
because of
yeah.
their relationship.
Except he was in the room when she offered Barnes the job.
Okay.
Uh, and he remembers shaking hands with Wade, but they didn't really talk.
I see. Okay. But I mean, that doesn't help them that much. Do you agree?
No, it I don't think it helps the defense, but I don't think it hurts them much either.
The government or the defense?
Either one.
Right.
He was
Well,
just
because
entertaining.
yeah,
They
but this
one of the defense lawyers says I've known you for decades, and Mr. Barnes, Governor Barnes, I want to tell you that I think you're the best trial lawyer in the state of Georgia.
okay.
it,
Nice.
it,
So
it was that kind of
old home
performance.
week. Okay. Right. But if the state called him as their witness, then they were trying to use him to show that Fanny didn't simply turn this case over to her boyfriend, that she made some efforts to turn it over to someone else. Fine, but that doesn't prove that you didn't turn it over to your boyfriend and that you're not benefiting financially from it.
Yeah,
Does that?
it's kind of irrelevant to that point.
Yeah, I
Yeah,
think so too. So, okay. And then the next witness they called was her father. Is that right?
her father, Mr. Floyd. This was not in the trial, but I looked him up. I googled him.
Okay.
Uh, he he has a reputation of being a founder of the Black Panthers
Right.
back in the late '60s, early '70s. Uh, but his bio also said when out in L.A. Uh, the Black Panthers murdered two people. Uh, he very vocally and publicly resigned and
Mm,
disavowed the Black Panthers and went to law
okay.
school.
Okay.
So he's practiced law ever since as a trial lawyer, trying cases all over the country, uh, various types, and had a stint with the um, international. Oh, I can't think of the name of the court. Uh,
Oh,
uh,
the International Criminal Court?
yes.
Okay. In The
Uh,
Hague?
I don't know if it's in The Hague or not, but it sounded like one of those that was prosecuting uh, genocide in
Right.
Africa
Right. Okay.
because he has ties to Africa. And
Okay.
he actually, before he came to Atlanta to live with Fani, he had been living in South Africa for
Okay.
4 years or so, kind of retired or semi retired.
Okay.
And he came to Atlanta uh, about the time she was running for the DA, stayed in her house, and the point of his testimony was two things. One, to gain sympathy for her, he described the threats she was under when she got elected, the constant threats of people threatening to kill her, painting stuff on her house, uh, described the security that was put in place, including a dog to sniff for bombs because there have been bomb threats. And after she got elected and putting up with that about a month or two, she moved out. he stayed there, he said, to protect the house, which she had built with her own money. It was a new house.
With her own cash money, did he say?
He didn't say where the money came from, but he said she had built that house, was living in it, and when she moved out for safety reasons, he decided to stay behind and try to see what he could do to keep the house safe. Take care of the yard, wash the paint off the outside where people had painted slogans and stuff.
Right, slurs and things. Okay, so
And
my question is, none of this is relevant, right? I
it's
mean,
it's pure sympathy.
right,
It's
straight up sympathy.
like they're playing to a jury.
Right, and there's no jury. So who are we playing to?
The judge and the
Think so?
and
Yeah,
and the and
and the
anybody's
TV.
watching. Anybody's watching.
And TV,
Well,
right?
I mean,
wasn't
you
wasn't
got to
the
understand,
point of
she's a
his
politician.
testimony though to also, provide some
Yeah,
credibility that she
yeah,
pays in cash?
exactly.
We're
Yes,
getting to
right.
that.
We're
Yeah.
getting to that. Yeah,
The
and I
second
wanted
thing,
to
the second
was
thing
about the
he,
money. Yeah.
yeah, the second thing he testified to was the cash.
All right, so let me stop
And
you there because I want to bring Erin in on this, because of what she said testified to yesterday. Because then we can then evaluate what Mr. Floyd had to say today. So yesterday, as we all know, Fani testified that she quote unquote reimbursed Mr. Wade for expenses that he paid on her behalf for trips that they took together. Now, their written papers seem to say that they took turns paying, not that she reimbursed him, much less in cash. Um, but that is what the both of them testified to in open court yesterday. So, Aaron, let me turn to you. Let's talk for a minute about what you made of that testimony yesterday from your perspective as a former IRS investigator.
I find it
How
highly
often did you
implausible.
have to deal with this issue of hoarding cash?
Well, hoarding cash is a extremely common defense in indirect method cases for tax cases and for money laundering. So it's a common defense for criminals to say, "Well, I didn't actually get all this money from my crime, or I didn't actually evade taxes. All this money I had sitting around, and that's what I was using." It's so common that it's covered in basic training, and it's a textbook defense, and it's something that IRS agents are trained very early, like I said, basic training to pierce and look into whenever we're doing a criminal investigation. So that would be one of the first things we would ask a subject during subject interviews. What cash do you have around the house? What cash do you have on hand? And that's one of the things that we would look at in financial statements. I find it highly implausible that she had that kind of cash sitting around. She is a very wealthy woman now. She's reportedly worth $8 million, but you're still talking about a fair amount of cash for all those trips. Talking about tens of thousands of dollars, as I understand it.
It would seem like it would have to be, given the number of trips and where they were to. Yeah.
And the other thing is that doesn't sit well with me is that there's no like receipts for any of it. There's no tracking of it, and so it's not just cash on one side; it's cash on two sides, right? So she's giving him tens of thousands of dollars. What is he doing with that cash? And he's purchasing all this stuff on his business credit card. He's in the middle of a divorce, so he's probably not only hiding money from his wife, but it probably is not paying taxes and expensing all these things as well.
Right.
It's
So he
all
may
very
he may
highly
not
improbable.
be. Yeah, he may not be. So this leads me to a point I want to make as we kind of launch into this part of the podcast, which is, we don't have enough facts, those of us on this call, to say for sure whether anything that these folks did is or isn't criminal, right? So, because a lot of times, especially when you're talking about money crimes, it depends on specifically what the facts are. So, we're going to talk about, well, it could be this and it could be that. But I want to caution people that I certainly am not saying, well, this XYZ is definitely a crime. If something is definitely a crime, then I'm not shy about saying so. But it's hard in this kind of an arena to be that positive about it.
Leslie, last night I
Yes.
said there was one crime, and that was kind of confirmed today, and
Mhm.
that would be Nathan Wade's false answer under oath to the interrogatory that asked whether during his marriage or the period of their separation did he have sexual intercourse with anybody else other than his wife. He answered no.
Right. And that's a good distinction. So there, we know what the answers were. We know enough facts to comfortably say this is a false statement, that would be a crime. So by contrast, with a lot of these other questions, a lot of these other issues, especially surrounding the money, they might be crimes, but they might not be. And we don't have the correct and accurate facts established, right? So, for instance, it seemed very unclear to me, her testimony yesterday, Fani Willis, about the money that she took from her campaign. The way she talked about it, it was unclear. Does she mean she took it out of her campaign donations, or does she mean the money she took out of her retirement account to use to fund her own campaign? And so the answer about whether that was criminal activity to continue to dip into that money could could definitely depend on which one of those it is. So do you see what I'm saying? So we want to be careful. We're not accusing people of committing crimes unless it's very clear that that's what's going on. And for a lot of these questions, I think it's certainly possible. And this is one of the things I wanted to discuss, especially with Aaron, is what things might there might be enough there to perk up an investigator's ears, right? To cause a prosecutor maybe to have some interest. Um, but you would need to have more facts and know all of the facts in order to say for sure that this is criminal conduct. So, but she did say some stuff on the witness stand yesterday about money that certainly caused me and a bunch of other people, lawyers on Twitter, to perk up and say, well, wait a minute, is that legal or not legal? So she talked about getting gifts from Wade. She talked about this thing with her campaign. Obviously, steering the contracts to him could potentially, be criminal or improper at a minimum. Um, and so I was wondering, for Aaron, from your point of view, from sort of the tax perspective, what things did you hear that caused you to think, well, if I were on a case, I'd want to know more about that?
Well, right, sure, and I agree with you. We don't know what the facts are because we're just sort of speculating based on what they say. But I would have been running to open a case. Not me because I didn't do political corruption, but um, we would have also someone would have been running in the office to make sure they put a number on on both of them before the day was out to sort of stake their claim. So the red flags, whenever you see a lot of ambiguity about who's paying for what
And how and with
and
what?
how, and not and vague recollections about where the cash came from, and you see that he's paying on his business card. So right there, it's a red flag already. He's paying for extravagant business expenses on his card. He's sort of already admitted to lying about the divorce. So another commonality in a lot of tax cases is during a divorce, it is very common, very common for them to lie to their CPA because you just can't lie on the divorce papers and then also not lie to the IRS. It's very difficult to keep
Right,
track of all these lies.
right.
So they wind up doing both, and from that perspective, it's pretty easy to prove because the CPA will come in and say, "Well, I just put down on the tax return what they tell me, and so he lied to me, so that's what I put down." And he's using his business card. He's in the middle of the divorce, so that makes it much more likely. You have all this cash going back and forth, so then you're thinking, okay, well, if she's reimbursing him for cash and he's buying this thing and they have this relationship and he's billing the government, is he also billing the government for time that he's spending in Aruba with her? Is there contract fraud? Is there any sort of fraud that's going on in there? And because of all the ambiguity and because of all the the seemingly like a lot of effort going into there's just so much protestation. They're protesting way too much for something that if they just had an affair, why wouldn't they just say, "Hey, like, yeah, we had sex, so what?"
Right.
That's
Well, the reason they're protesting so much and they decided on this, it was all cash strategy, is because of the allegation, right, that she gave this work to him and his firm and his partners or co-lawyers, whatever they technically were, and then he turned around and spent the money on her and, well, them as a couple, but partly on her. And so, in order to say that that's not true, she had to say that she reimbursed him. But then the problem is, it's not like she has checks, right, from her in her account that are made out to him that say reimbursement for airline tickets, right? That would be a whole different story if she had those kinds of documents.
right, and
So,
it all smacks of something that they created on the fly, and
after the fact.
it doesn't jive very well with reality. And you're as a financial investigator, you're knowing like, okay, the chances of her having that kind of cash around it are is pretty slim. And then even the cash with that kind of cash is going to leave a trail somewhere. Because again, she has the cash, so she's giving it to him. What is he doing with it? So is he putting it in his bank? Is he keeping it at his house? Is he spending it? There's sort of things going on there, and
Should that money not, or should it not have maybe gone into his firm instead? So, one point I wanted to clarify that people seem to be confused about on Twitter is this question of whether Wade was um, not counting the money she gave him allegedly as reimbursement as income, right? And people were kind of quick to say, "Oh, well, that's fraud." And from my perspective, and I defended not a lot, but I did defend some tax cases, and um, actually my first year of law school that summer, I clerked for the Internal Revenue Services Office of Chief Counsel. So I know some tax law, and certainly from a criminal perspective, what the issues are. So I want to caution people that just because you don't count the reimbursement as income isn't necessarily tax evasion. Because if you didn't claim those costs as expensed business items in the first place, then it's not income to
right,
you,
if he had
right?
purchased everything on his personal credit card and she gave him cash, then that's not income. The big
Right.
issue where I see is the use of the business credit card, and what's common for businesses to do is basically give that credit card receipts to the CPA and say these are my expenses, and they expense that whole thing, and he's expensing his entire trip, including her portion on that credit card, and then somewhere that cash is coming in, and my suspicion would be into his personal pocket, and the divorce sort of leads credence to this because the divorce allegations are going to say that he hid money, and undoubtedly that's going to be part of if it's not part of the divorce filing already, it certainly will be.
It will be, right. It will be.
Yeah,
Right. So really how he handled it with his accountant and how the accountant reflected it on the tax return, because like we talked about yesterday, I thought it was clear as mud whether that credit card was his, whether it was the firm's, whether he seemed to say he put all of his expenses on one card, but that doesn't necessarily mean that he and his accountant put all of those expenses as items that could be deducted as business expenses on his return, right? Those are two different things. So, and how he treated it, exactly how it was treated for tax purposes, makes a difference as to whether it's then a problem that he doesn't turn around and count her reimbursements, which she allegedly gave him, as income. But it seems also to me, King, what do you think of this? And tell us, how is the judge looking at this
but before,
yesterday and today? That, well, let me ask my question first. That, what does it have to do, really, how the tax treatment is, seems to me to be pretty far afield from whether this is conflict of interest or not.
uh, short answer, yes. But before I get there, let me explain to Aaron and the rest of everybody here. There are about four distinct areas that people are looking at Fani about for this particular contract. First is the issue that the judge is trying yesterday and today. That is whether the personal relationship plus financial arrangement between the two created a conflict of interest or appearance of conflict of interest in this criminal case. Second would be uh, the contract itself, which she did not seek the approval of the Fulton County, what is it, Board of Commissioners or whatever body normally approves.
She didn't use the normal process for letting the
Cor-
contract. She did not.
Correct. And whether she uh, adequately disclosed things like personal relationship and a travel arrangement whereby they exchanged money, cash, and gifts. And then the other one is not related directly to the contract, but could be, and that is apparently whistleblowers in her office have come forward with allegations that she has misspent uh, or misused money coming into the office, mostly federal, uh, and not properly accounted for it and not properly used it for its intended purpose. And that could lead to these lawyer contracts. It could be that's the source of some of the money. So all of those, she's under the magnifying glass uh, of both state and federal officials, potentially criminal.
And that doesn't even count the
Yeah,
tax stuff.
well, from my perspective, it's
Right.
okay. She was having an affair. Okay, if that was just that you're sort of, unfortunately, that's ubiquitous in government. Um, so we wouldn't even think about that. But then, okay, now the contract wasn't awarded in the correct manner. Okay, those two things together, maybe you're thinking, okay, well, it doesn't sound good, but maybe not enough to know. But then you start getting into these these trips and the cash reimbursements, and the cash reimbursements sound super dubious. Super, I'm skeptical about her explanation of the cash, and it sounds like they threw it together after the fact. There's and conveniently no trace that they can provide. You sort of looking at one thing after another, and you're sort of thinking, okay, there's just so much here. I wouldn't want to bet that there's not something wrong there if I were the judge. But and as a criminal investigator, I would think, okay, all I have to do is open a case, and if I investigate it long enough, I'm going to find something. Especially given
Right.
Wade, when you have someone in a contested divorce doing all this stuff, the likelihood of having wire fraud or a tax case, and usually we would try to do both, because it puts defendants in this position of having to either deny the one and say they committed tax fraud, or just admit to the fraud outright and say they didn't mean to do tax fraud. Either way is not good.
Right. And sometimes, as I was saying before, you get to the bottom of all of it and it looks bad, but there's no actual criminal conduct because the person has sometimes even tried to do things the wrong way, but they haven't technically violated the law. So, yeah. So I agree. Based on what her testimony was yesterday, there were a number of things that I thought, "Ooh, somebody might want to take a look at that." And we haven't even King, your list didn't include whatever's going on with the money she used from her campaign. And again, maybe that was perfectly legal. Maybe it wasn't money from contributors. Maybe it was her own money that she'd be allowed to use that she took out of her retirement account. But her testimony about that was sufficiently unclear that I think a motivated investigator would have more questions about
Well,
that.
also, it just goes to the implausibility of it. Why, if you have
Yeah.
cash in your house and that's normal for you, why do you need to justify it by saying it came from your campaign? You would just say it, no, I just keep cash all the time. I've always had cash. I deal in cash.
Right. I always have X
Oh,
amount of
but
cash on
well,
hand
that's
for
not really
emergencies.
true. What's
Right.
really true is I had this cash hoard I kept. So, the story
Right.
starts shifting and changing, which is, another red flag
Yeah.
that we would look for.
Yeah,
But you
on
made
that point,
go
that
ahead.
it did come out yesterday that she told the authors of a book that just came out that she was pretty much broke at the end of her campaign, and there was a tax lien, about a $47,000 tax lien on her property, and she was uh, out of money. She spent all her money on the campaign. That was her testimony.
So,
Except for this hoard that she had that she wasn't using to pay off her taxes.
yeah.
That's a hoard of some undefined dimension.
Well, the thing too is with her position, she's going to have multiple ways that she filled out financial affidavits, whether it was for loans or it
Right.
was office,
Exactly. Right.
and a cash,
Right.
you know, cash at home would be something that you would need to report. And so, the IRS is going to look, the criminal investigator is going to look for a starting point. And I think she was divorced in 2005, which is a long time ago, but still recent enough to go back and pull those records and start putting together, how much she made.
As a
Yeah.
baseline. Right. From there, what happened? Yeah. Right. Well, Aaron, you raised I thought an excellent point on Twitter today about and now we're going to get to her father. So they called her father as a witness today, obviously with her approval, and probably it was her idea, right, to call her father to corroborate her testimony that she does keep cash on hand, and why that is. And it is often a good tactic as a lawyer to have someone other than the person who is under scrutiny, to have another person, even if they're a family member, come in and say, yeah, this is what we always did. This is what happened. Here's some examples of it. That can be powerful proof. So I'm not faulting her for wanting to call a corroborating witness. It is always a little problematic when it's a close family member. But that's why they wanted to call him today. But Aaron, you had an interesting take on putting him up on the witness stand and from the perspective of an investigator. So tell folks about that.
I don't even remember what I said about that. But
Ah,
I
you were
would tell you
saying,
that I thought
this
it was
is
a mistake for any of
yeah,
them to testify.
yes, right, exactly. This is the point you're making.
So,
Go
I
ahead.
mean, she didn't have to testify, as I understand it. She volunteered to do so. So the more everyone testifies, what's great for an investigator is when you testify in court because it's all transcribed, and the prosecutors can't doubt that you didn't ask the question 500 ways and they didn't misunderstand the question. That it's all clear. So you're basically locking people into a story, and
And you've sworn to tell the
right,
truth.
and they're lawyers, so they know better. And
Right.
what also doesn't work out very well when you bring in relatives is in this. I've seen it happen with character witnesses. You start getting. I mean, for this purpose, it might be fine, but for a criminal case, you start asking them, well, obviously you didn't know them very well because you didn't know about this thing, did you? You didn't know about this. What about this event? Well, you didn't meet her boyfriend until 2023, so obviously you didn't know what she was doing. Well,
Right. And that was a weakness with this witness today, is that they did that exactly that same thing to him. He didn't know she was dating Wade. And yet he's providing testimony that, he knows what's going on with his daughter. And those two things can't be true at the same time.
right. So it can, in a criminal case, that can make the defendant look a little worse because it looks like they're not just lying to the government; they're also lying to everyone else around them.
Mom and dad. Right.
And there's really no reason to do so if everything was on the up and up. Like if it was just an affair between two consenting adults and there was nothing to hide, then why is there so much effort to create all these backstories and why is the story shifting? There's just so many different red flags and so many vagaries, and those vagaries though lock them into a particular
Right. And that's the point you were making on Twitter, which I thought was the excellent point, which is her father is now also locked in. He said whatever he said today, right? And so now they're stuck with those facts. So and they're not thinking about the potential ramifications of the testimony that they're giving for other fora, for other places or other, bodies, authorities who would be investigating
Yep,
them.
there goes the
This is
defense
one of
that
the
he
reasons.
gave her, 60 grand.
Right, as a gift to her for her birthday or whatever. Right, exactly. So yeah, you've locked yourself in to what you said and also what you didn't say. So okay, but King, what did you make of his testimony? How did he come
Well,
across as a
before I get
witness?
there, let me answer your last question, which
Ah,
was
uh huh.
the tax issue hasn't really been raised. Um, they uh, they may have some tax returns, but nobody has pointed out anything about them. Nobody has said, "Look here, you've deducted these personal trips as business expenses." Nobody has said that. Uh, Nobody has raised the issue of whether gifts to Fani in the form of trips or otherwise uh, were or were not on her tax return as income. I don't think they have hers. Uh, they may have got,
I mean, I'm not
yeah,
surprised at that. Are you? If I were a judge, I wouldn't have let them ask about that. That's not really relevant. The tax
no,
treatment is
it's
not
absolutely
relevant.
not relevant, and nobody asked, and it's never really been an issue. Now as to Mr. Floyd, uh,
Let me say before we move off that point, that won't keep tax people like agents like Aaron from being curious about it and from investigating it. It's just that it's not relevant to the issues in front of this
that is
judge.
true. Uh, as to Floyd, he I agree with Aaron. His statement that he had no idea that she was dating uh, Wade at any time uh, really was a bad fact for her.
Maybe that was because they were leaving the state to have lunch, so he
Yeah,
couldn't keep up
yeah.
with all that.
I mean, she, and in contrast, he said when he first got there, uh, before Wade came on the scene, she was dating a DJ. And the DJ was there all the time and leaving his equipment in the way. And, and Floyd would have to push it out of the way to walk into the house. So
Oh,
the
okay.
contrast was uh, impressive, to say the
Mm.
least. Uh, as to the cash, I expected him to come and to the stand and say, "Oh yeah, there was a safe, and she kept her cash there. Uh, we talked about the cash, or I saw her go in and put the cash in or take it out."
I taught her how to do that when she turned
Yeah,
17 or whatever. Right. Yeah,
none of
right.
that. Absolutely nothing like that. He didn't stumble upon any cash. He didn't see any cash. He All he said was that it's a black thing. That that's
Right.
how he raised his daughter. That's how most people uh, in the black community growing up live and believe. They think you need to have a ready source of cash stashed away somewhere in the house that you could get to if you needed it. So that was all he said.
Right. Now, I don't know if that was true or not in terms of whether the black community has that practice, but it struck me from sort of a legal and evidentiary point of view that his proper testimony was that he had taught his daughter this practice and that he knew from time to time, because she's a grown woman now, right, through her life, that she was carrying out that practice. And yes, she always kept a certain amount of cash, whatever it is, to his knowledge, in the house, right? He didn't need to go farther and say the reason for that is because this is how black people behave. He chose to make that statement, and okay, he can say that. There's nothing preventing him from saying it. But I didn't think, from an evidence point of view, that that was necessary.
Well, from an evidence point of view, his evidence was remote as to whether she had any cash.
Anytime in the
At
recent
any
past
time.
that he'd seen.
Yes,
Right,
this is
right,
what I taught
right,
her, but that's as far as
right.
it went.
That's what I'm saying. I thought it would have been more powerful testimony if he had not said it, or instead of saying, "Well, this is something that black people do." If he had said, "I had this conversation with this was a practice I maintained, and I had this conversation with my daughter as she came of age that this is the way to to do things. So you always have a safety net, and blah blah blah, whatever the reasons are. And I know she's been doing that as an adult all these years. That would have made sense. It wouldn't matter what race the people were or culture or whatever, right? It's just transmission of a practice from father to daughter. That I thought would have been fine. Then you could decide whether you believe that or not believe it, right? But injecting this extra thing of, well, it's almost like he was testifying as an expert witness about black culture to this white judge, and I thought, oh, okay.
That's pretty much what it was, or what it came across as, and to the point where nobody really went after him on cross on any of that.
Right, because what are you going to say
Yeah.
about that? No, you're wrong. I mean, it's so. Okay,
Yeah,
yeah,
it strikes me as something you say when you don't have actual facts.
right. That is how an investigator would look at it for sure.
Well, that's how I looked at it, because I
Yeah,
fully
yeah,
expected
I
him to come
understand.
in and say, "Oh yeah, I stumbled into a closet and I found a bunch of cash." He didn't say that.
Right.
I expected him to
Well,
come in
because
and
she
say that
said,
he gave her cash. Like that's what I would have said. Like, oh yeah, I gave her
right,
cash all the time. Like, of course, I'm a
right,
good father. Yeah, when I came in, I gave her cash. Of course, she had cash all the
right,
time. Like everywhere we went, there was cash. But instead, we had
right,
this sort of,
right. It was never a problem. We were always flush.
And
Right. Yeah. I
he,
don't know.
he kind of debunked that. Had he tried, he said in all the time since he moved into the house and later moved out, he has seen her 13 times for maximum time of
Mm-hmm.
visit 4 hours.
Right.
So he rarely saw her when she moved out.
Yeah. See, that's effective. Those were questions that were brought out by the defense lawyers. How often he had contact with
Yes.
her. Right. And that's an effective way to punch holes in the testimony of a witness who's talking, as Aaron is saying, in such sort of vague, broad
Mhm.
generalities. Then you say, well, how often did you see her, for how long, on what days? And then it's what he's seen her 13 times in however many years. How would he know if she had cash in the house
Right.
regularly then? That's why it would have been better testimony for him to say this was historically something he taught her, and he knew that whenever he would come and visit her, yeah, she still had her cash
Well,
uh,
he
stashed away.
also clarified that he didn't even know where she went to live. He
Right, right. I thought
so
that was
he never
entertaining.
visited her where she actually lived after she
Right.
moved out, which would have been around February or March of uh, 2021.
Okay. All right. How did he seem as a witness? He just looking on the videos, I mean the pictures on the internet and the little clips, he seemed uh, in some ways like just um avuncular is a word I've already used, but that he just seemed like a nice, middle aged to older gentleman there to support his daughter.
Uh, and I came away believing he's a sharp lawyer, still sharp. He still has it, uh,
Mm-hmm.
even though he's retired. And it, to a jury would love him. So
Right.
he's that kind of person.
Right. That's what I thought. He came across that way too. Okay. So that probably helped them a bit then. Hey, Ship, can you hear us?
Yes, I can. Had my mic turned off, but I'm here.
Okay, fantastic. It's good to see you, my friend. So that helped them a bit. I think that his testimony helped them more than the governor did, but his testimony also hurt them quite a bit, I thought, because of the issues you've been pointing out, King. So that what happened after that?
Unless I'm forgetting something, I think we broke for lunch and then came back after a good long wait to hear Mr. Bradley, uh, who took up most
Boy,
of the rest of the day.
he really looked like somebody who did not want to be there.
Oh no, he did not.
I felt bad for him, actually, in a way. Okay, so did they take up all these issues about attorney-client privilege after he got there, or while they were waiting on him?
No, they waited for him to even open court.
Okay.
And as soon as he took the stand, they launched right into the attorney-client privilege issue. And the way they did it was interesting. Miss Merchant took the lead for the defense, and she established there are many objections throughout all of this, but she got him to say, first, he didn't remember her calling her, although she represented that she had. They talked on the phone, and then after that they texted, and the sum and substance of the texts were that uh, Bradley told Miss Merchant back in September. No, not in September. They first made contact in September when uh, she had asked him about some corporate or law partner documents and stuff. But then in January, they reconnected, and he told her that that Nathan Wade, had told him that their affair had started back when both of them had some association with city judgeships. They'd gone to a city judge or some kind of judge conference out of town, and that's where they met in October 2019. And that's when the affair began. Uh, and maybe before that, back in their judge, back when he was running for judge, and I don't remember what her involvement with being a judge was, but he said he put it he tied it to that period of time. Wade had hired him as a lawyer, a divorce lawyer, 2017 or 18. So it was sometime after he retained Bradley that he admitted to Bradley he'd been having this affair with Fani. And that came out through the mouth of Miss Merchant, reading texts, and other side objecting. That's privileged. We can't put that in evidence yet. We have to see if it can come in under some exception to attorney-client privilege. He did say, he said, yes, that was. He said, since I did that, I found out I made a mistake. I should not have disclosed that.
He found out he
Yeah,
waived
I should
his
not have.
client's privilege.
And the judge was pretty clear. He was buying the state's position that he doesn't have. That is, Bradley has no authority to waive the privilege. So,
Yes, that's
so
right. He doesn't have the authority to waive it, but he opened his
he opened a
mouth
mouth,
and words
and
came out.
that's
So,
how Miss Merchant got it into the record.
right.
But she needed to ask a couple more questions, which such as, is this your personal knowledge that they were having an affair? Is this something he told you? And did he tell you in confidence as his lawyer? Uh, Questions like that the judge wanted to hear the answers to. So they went through that routine. Uh, Bottom line,
So let me ask you a couple of questions. Were Wade and Bradley friends before he hired Bradley to be his divorce lawyer?
They were partners.
They were partners before
Yes.
Bradley
They
became
were
his
sharing office
lawyer.
space. This is back then. They had not formed a formal 3-man partnership, but they each had their own PC, professional corporation,
And they were sharing
and they were
space.
sharing office and fees and expenses. So
Okay.
whenever one of them got $1,000, that got split 3 ways.
Okay.
Yeah,
So they had a professional relationship. It sounds like they were friends too.
correct.
Okay. And then he hired Bradley at some point after that to also be his personal
Yeah,
divorce lawyer.
and he remained his personal divorce lawyer all the way through the divorce case filing, which was the day after Wade got hired by the DA's office to be the special prosecutor on the Trump case. And he remained Wade's lawyer until sometime in 2023, when he quit the firm and stopped representing Wade.
Okay. So let's make sure so people understand. So for attorney-client privilege to attach, you have to have a lawyer and the other person has to be seeking legal advice from that lawyer. Okay. So, and that's the law's a little bit different everywhere, but those are the basics. If one person is a lawyer and the other person is seeking legal advice from that lawyer, then you have established an attorney client relationship. Now, it doesn't matter whether you're paying that lawyer, it just does not matter. Um, really, pretty much anything else. But in this situation, it's all muddied up, right? Because these two guys are friends before they established the attorney client relationship. And so things that Wade told him before Bradley became his lawyer would not be privileged, but things he told him after Bradley became his lawyer could have been privileged. And then you have the further problem that if Bradley did the filing with the court that gave Wade's false answer to the court about any extramarital sexual relations, then there's another kind of way to attack what is otherwise attorney-client privileged information, which is if you're using the lawyer to communicate your statement to a third party, the court could be one, or let's say you're using the lawyer to communicate um, contract terms, the contract offer terms. If a person uses a lawyer to communicate terms to a third party or information to a third party, then that might not be privileged information. And then you don't have to worry about whether you're invading the attorney client privilege because it's not privileged to begin with. And then on top of that, sometimes, especially prosecutors, will try to get to information that is covered by the attorney client privilege by saying that the client and the lawyer are engaging in what's called crime fraud. Basically, that the client is using the lawyer to conduct some kind of improper or even criminal activity. And then the law varies different places as to how much knowledge the lawyer has to have that the activity is criminal. Um, so the judge had to basically ramble through all of those things this afternoon, right?
Yeah, yes, and the judge wanted very much to hear all of the evidence as to how Bradley had acquired this information, even though uh, everybody pretended nobody knew what it was. But Miss Merchant had spilled the beans on the record. So, um, and Bradley was adamant it only came to him during their attorney client relationship. It was a privileged conversation. It was related to his work for Bradley for Wade as his divorce lawyer. He did not give us, if he said it, I don't remember it or I missed it, a specific time when he learned it, except that it happened after he started representing Wade.
Let me ask you this: did he say he learned it after he filed the document with the
He
court that said the answer was no?
he did not say. The document that was filed in the court was filed by the successor lawyer.
Oh, I see. Okay.
So he had left the scene.
And he's off the hook
He
for
was
that.
off the hook
Okay.
for that. And the only thing he knew that about Miss Willis, that other than the contract stuff that relating to a relationship to Wade, he knew of a trip or two the two of them took.
And that's for his personal knowledge,
Correct.
right? Like what he
That was,
saw and
yes.
heard.
He didn't
Whatever.
claim that was
Yeah.
privilege, but he knew they went
Okay.
off to an island somewhere. That's all he knew. Uh,
But see, how can you square that? Did he know that before or after the divorce?
well, it had to be after
He became the divorce lawyer. Okay.
because they didn't meet until after he'd been hired as a divorce lawyer.
Oh, that's right. He's saying he hired him as a divorce lawyer in 2017.
2017 or 18. Right.
But he didn't file for divorce until when?
November of 2019. They filed divorce on
Okay.
the 2nd of November, the day after the contract was signed by Fani, giving Wade, appointing Wade the special counsel in the Trump case.
Okay. All right. So, what did the judge let in and what did he keep out?
He let everything in, really, except for what Bradley was told.
Okay.
Everything that kind of walked up close to that conversation they had, he allowed. But as to what Wade said and anything about it, he kept out. So the defense lawyers argued. They argued two things. And this is where the nerd part comes in. If you're a legal nerd, start recording this. This was interesting.
It's already being recorded,
Yeah.
people. You don't have to record it.
Miss Merchant took the lead. She was asking the questions. So she argued this has to come in, Judge, under the crime fraud exception to attorney-client privilege. And her argument was kind of garbled, but basically she said, well, look, Mr. Wade filed a false sworn discovery response in the divorce case, which is a crime. So before,
Okay, but was Bradley the one that helped him do that? I thought it was
no,
a
there was no
different lawyer.
evidence Bradley had helped him do that, and and
How's that
and there was
helping
no
him?
evidence tying the, and they probably wouldn't have got it out of this judge anyway. No evidence tying the advice, which we're not supposed to know what it was, to the filing of that false statement.
Yeah. Okay.
But she was saying, regardless, you have a privileged communication and then basically a fraud by the client, and you tie them all together and it's crime fraud. And
Yeah, it's not really how
I
that
don't know
works.
how
So,
it works either. Where,
no, I do know how it works, but that isn't it.
but whereupon Trump's lawyer stood up and
He had a
he
different
had a
argument.
different argument and a different case. He had a case out of
Okay.
Ohio
Mm.
that I hadn't read the case yet, but it's a case out of Ohio, basically that says where an officer of the court or the client, I don't even think it has to be an officer of the court, where the client takes the stand and commits perjury and says something that is contradicted by what he told the lawyer has an independent duty to correct the record.
Well, that's true if you're the lawyer in the courtroom with the client doing that, but that's not Bradley's
That I don't
situation.
know how far that Ohio case went. It wasn't
Yeah.
clear. There's another argument that if I had been there, I would have made, having tried these kind of cases before. I would have argued very strongly that that information was never privileged. Take a hypothetical. A client comes to you after a car wreck, and he tells you, I've hurt really bad. I got hit from the side by this other dude. He's in the wrong. And I said, well, was it an intersection? He said, yeah. I said, who had the green light? Well, he did, but he shouldn't have hit me. And I said, so you had the red light? Right. I said, you understand? And said, you want to sue? Right. You understand when you sue, you're going to have to disclose either in the suit or in answers to interrogatories or deposition. You have to tell the truth and tell them what you just told me. The light was red.
You ran
You
the red
ran the
light.
red light.
Right.
He says, screw you, King. You're fired.
You're fired. Then he tells the
And so he
next
tells the
lawyer a
next lawyer
different
a different
story.
story. and,
Right.
and the issue is the statement that he ran the red light, is that intended to be privileged? Because if you're hiring a lawyer to file a lawsuit for you, to file something in the public record, you have to explain to the client, most lawyers do, that what you tell me is not confidential anymore. I have a duty as an officer of the court to put it in the record. So that's one of those facts that some courts will say is never intended to be confidential. It's intended to be disclosed as part of the lawsuit you were hired to file. That could have been argued here. What do you think?
So yeah, it's akin to what I was saying before about if the client is using the lawyer to communicate information to a third party, and you know you're going to do that, like a contract officer or a contract offer or filing with the court, right? Then that's not privileged information
And,
um,
and I'll
for
go
that
further than that.
purpose.
If it's
Yeah.
not privileged information and the lawyer has it, and he learns that lawyer number two has filed false, no, that the client knows is false pleadings in the court, and the lawyer is in on it. There are bar rules requiring lawyer one to report lawyer two to the bar, and maybe to the court.
If you, I would agree with that if you know that lawyer number two knows that the facts are other than what he's representing to the
Exactly.
court. But if that lawyer is in good faith relying on the client and you just know
Right.
that the client is lying to
Yeah.
him, there's nothing to
You have
report
an issue.
there.
You do have a dilemma as to whether it's so outrageous that you have to report. But even if you decide you don't have to report, if you're called as a witness as to what you were given in a non-privileged setting, which is give me the facts that I'm going to go put in your pleading, you can't claim privilege. The client can't privilege, should not be able to stop you from giving those facts.
Right. So it's interesting because as a defense lawyer, I almost never, I did some plaintiff's work, but just a small percentage of my overall practice. This would just never be a problem as a defense lawyer, right? You would, because you wouldn't be in a situation where the client's telling you things that you're going to convey to the court, that are where you know that you're going to put them in a pleading, right? It's a different kind of
Exactly.
practice.
But in civil
Yeah,
practice, in divorce practice, uh,
right.
and things like that,
I can see it would be more of a
and more of a
problem.
problem.
Yeah.
And if you've done some plaintiff work like I have, you've had a lot of lawyers have experience in busting that privilege claim on that very basis.
Right. Yeah. So that's but that argument wasn't
Was not
raised,
raised.
and the judge looked to me like from a few reports that I saw that they were kind of all over the place about the law of privilege. But then it seemed to me it kind of worked out that the judge made the right rulings, that he kept out what was privileged and let in what wasn't.
He did, but he was intrigued enough, and the defense convinced him to talk to Bradley in camera, which means
Okay, and in camera means, I'm sorry, King, I didn't mean to
go ahead.
interrupt you if you were going to explain it. Yeah, in camera, folks, means in private with the judge, not in front of the jury. Was it ex parte in camera?
Yes.
Okay, so ex parte means one side only. So ex parte in camera means one side goes back in chambers and talks to the judge privately about what the testimony is going
Well,
to be. And
in this
although,
case, it's neither side. It's only Bradley.
oh, he didn't, because, wow. So this was a defense witness, well, under subpoena to
Right.
them. And he went back with Bradley and his
He's going
lawyer.
back. They're going to arrange a convenient time to meet next week, probably. But he's going
Okay.
back alone with Bradley, and he's going to ask Bradley what Wade told him, A to Z,
Wow.
what the
Mm,
circumstances
this
were.
is dangerous. This is dangerous for this judge to be
He's
doing
doing
this.
it, and the defense,
Next, he'll be doing court's
yeah,
exhibits, and I know how that turns
and
out.
the defense asked him to do it.
Oh, the defense
Yes.
asked him to hear him out. Well, because they think once he hears what he has to say, he'll put it on the
Well,
record.
once he hears what
Okay.
there's whether he puts it on the record or not, he
Yeah.
can't unhear it.
Right. But I just can't see how it's appropriate for the
It's
parties to not know. Yeah.
the
This is
it
problematic. But there's another reason why he's doing in camera ex parte with Mr. Bradley, right?
uh
This didn't it blow up at the end about whether or not he had engaged in some
yeah,
misconduct?
that's what he's interested in. I'm sure he's interested. He's interested in not no that he set up the in cameras thing before that stuff at the end about
Right. Yeah, but
Bradley.
I'm saying he's probably gonna cover this stuff too, don't you think?
I doubt
Good
that. I
grief.
don't think so. That was
Oh, did they resolve
there was
that? I couldn't figure that part out.
that was on cross by the state, Miss Cross.
Right.
Um,
Right.
she
Miss Cross on
on cross
cross.
got him to admit that he was he left the firm because he was asked to leave the firm because he at a time when he was accused of sexually assaulting an employee and sexually assaulting a client.
Okay, assault or
Assault.
harassment? Did they say
Assault.
assault?
They used the
Okay.
word assault both times.
All right.
And
All right. So
he denied it. He
of course he
he
did.
denied it.
Right.
And then the state called two witnesses. One a
Now wait, King, wait. Did the defense object to
yes, they
this?
objected to the two witnesses.
Did they object to even asking these questions? Because I'm not sure that this is relevant
I
impeachment
don't
or proper impeachment at all.
I don't think they objected to why he left. But they did
Wow.
object to both witnesses who were going to testify. Uh, one of them was one of the assault victims, and one of them was
Oh
a
man.
employee who saw the first insult, and
Gee, man.
they objected and got both of them stricken on
I guess
on the.
so. Ship, let me bring you in on that. What in the hell? That's not proper impeachment, do you think? Ship, can you hear us? You gotta unmute yourself. Ship, have you abandoned us? Leslie to Ship. Oh, he's not taking his speaker thing off. I'm going to send him a text message. All right. So, can you tell me if you think this differs from your understanding of the law? But
Um, it
you can't. I was telling people on Twitter, you can't, just because the person's up on the witness stand doesn't mean you can ask them whatever you want about when was the last time you beat your wife and have you stopped kicking
it
your
it's
dog. Like you're not allowed to do that.
yes, it I forget the term.
Prior bad acts.
It, and there's another term relating to
Mm-hmm.
extraneous
Yes,
issues.
collateral.
Collateral. That's the word I'm looking for.
Yep.
Um,
Yep.
and that was the grounds for uh, striking both eyewitnesses.
Well, I mean, the horse is pretty much out of the barn if you after you've already asked the
Well,
question.
no, they know what the collateral issue on impeachment is
Extrinsic, extrinsic proof is
you can't raise an extrinsic unrelated act to set
right.
up an impeachment. So, which is what they
Right.
did. They got him to deny it.
Yeah.
Now they're going to
Exactly.
call
They did
two witnesses
exactly
to
what the
show he
evidence
lied.
rule. Right. Exactly. He lied on an issue that doesn't have anything to
And,
do with this
yeah,
case.
and that's
Right.
what they had done. They did not
Yeah.
catch it in time to stop the denial, or the even raising "Why were you fired?" But when they've tried to bring in the impeachment witnesses, the judge threw it out.
Yeah. Well, I'm not surprised that they did that because these are rules you learn in evidence, right? And I've seen twice lawyers try to do this, and both times it was prosecutors because they seem to have the view, state court prosecutors, I will say, they seem to have the view that if they know something bad about a defense witness, something that will make them look bad, that somehow that transforms it into evidence that goes to their credibility. Right? Even though it
Yeah,
has nothing to do with the case, that doesn't make it impeachment or bias
Well, and what
evidence.
they were doing,
you know what? I'm gonna. Can I jump
yeah.
in here?
Sure.
I don't think the doctrine of collateral impeachment applies in this kind of proceeding. It certainly applies in front of a jury.
Yes.
The judge can hear it for whatever he wants to hear it for. I do not think the doctrine applies here, and I think it's his inexperience, the judge's inexperience, that led him to the conclusion, oh, this is collateral impeachment. You never get to do that. That's not true.
I don't think that's well. Let me say this. I'm pretty sure that under the rules of evidence in at least Maryland, that it it's not admissible evidence.
The
This
rules of
this
evidence don't
kind of
apply.
this
The
kind of
rules of
evidence.
evidence, the rules of
Well,
evidence don't
that
apply to this
they're not
proceeding.
in full effect. I agree because you're not in a trial proceeding. So you're technically right about that. But the reason that this kind of evidence isn't allowed is because it's highly inflammatory and only marginally relevant.
But
Right?
And correct. And if you had a jury, it's a prophylactic against
Right.
the jury being influenced by something that is of marginal relevance and
Right.
it leads down rabbit holes, and
Yeah.
it's a disputed fact about a, a, a
About
matter
an
that's not an
irrelevant
issue.
issue. Right.
Right. But
Right.
when you're proceeding for a judge
Yeah.
where the rules of evidence don't strictly apply because you're not talking about guilt or innocence, then I'm not sure. Yeah, and again, though, I think this is judicial inexperience thinking, oh, that's never allowed, and that's not true.
Chip, I'm going
Well,
to have to.
you are right
I
about that.
disagree with you here. Uh, we're talking about a hearing that was in the last hour of the second scheduled day, the last day of this that was scheduled, and they had nothing going next week. It was going to be over and submitted after today. And as the judge pointed out when he ruled, he said, "If I've let you testify, Mr. Employee and former client who was assaulted, uh, we have a
allegedly.
mini trial on that issue,
Right.
and
That's the
yeah,
justification, guys, that the rules of evidence and the judges use, is that it becomes a trial within a trial.
And I don't disagree that it's within the judge's discretion to allow that. But he could have allowed it if he wanted to. It would have been an error in front of a jury.
Yes.
Now, it's not necessarily error had he let it take place.
Yeah, no, I agree with you. In a hearing where he's the finder of fact, that you're right about that. Um, but I've just been struck through my career that this is something that good lawyers know you can't, you really can't do it this way. And the people who always seem to try to do it that way anyway are always prosecutors. And I think, you know what? If you're working that hard to try to discredit a defense witness because this person is credible and telling the truth and what they have to say undermines your case, maybe that should be making you think twice about your case instead of dredging up this nonsense about this
it,
witness.
it's curious in this case, Leslie, because this guy Bradley didn't say anything bad against Wade.
Right,
Nothing,
right,
nothing. He said
right.
he's still friends with him. He said,
Well, that was sad,
yeah, it
wasn't it?
was.
That part was
But
sad. Did you? I don't know if everyone saw this. The woman cross-examining him said, "You're not partners anymore," and he agreed with that. And she said, "And you're not friends anymore." And he just looked at her and he said, "Well, if he's saying we're not friends anymore, then." And the defense objected to that, saying, "Well, that's not relevant." And the judge correctly in that instance said it is relevant. It goes to bias, whether they're friends or not, right? They were, now they're not, whatever. And so he let that question in, and I would have too. And she said, "Well, you're not. Do you think you're still friends with him?" And he paused for quite a while before he said, really sad, "Well, I mean, I think I'm still friends with him." And I thought, man, this guy,
but
because he wasn't saying stuff that hurt them, and then he got all this dumped on
but
him.
but but in his testimony, he did not come down on Wade or Willis. He
Right,
didn't. He
exactly.
didn't say anything contrary to the state's case. All he had done was admit to Miss Merchant, yeah, I sent a
Right.
text I shouldn't have sent.
Right, exactly. So they went after him too hard, I thought. But did it come across that way, do you think, Kate?
To me, it did. Yes. Yeah, they
Yeah,
beat up somebody that really was. He did his best to protect their side by keeping
right.
that evidence out.
Yeah. So ultimately, what did you infer that the judge thought of his testimony?
Uh, the judge took it for what it was objectively, which is a lawyer's testimony about having a conversation
Mm.
with a client where the client is no good.
Right. Oh my. Okay. So that's how it ended on this fireworks over this extrinsic proof collateral attack type problem.
Yes. Yes.
Okay. But they're coming back Tuesday because the judge, he wants to hear this testimony from Bradley outside the
Yeah,
courtroom.
he's going to hear Bradley outside the courtroom. They're going to submit some telephone bills that they subpoenaed weeks ago, but just came in a day or two
Right.
ago.
That's always the way that
Yeah.
goes.
So
Yeah.
other than that, the case is submitted, and they're going.
Well, I don't understand. Ship, what do you make of that? Why it's a, like, as you say properly, it's a judge proceeding. Why would he have to hear it in camera?
He may just want to be protecting whatever the subject matter is from public disclosure.
For
Not
Bradley
no.
and
Yeah.
right, right.
Well, yeah. So if it's attorney-client privileged information, then what he will say is, look, as the fact finder, but as a judge, if I determine that it is privileged information, I'll set it aside and not consider it, even though it comes out. But I'm not going to expose it to the public because that would
Well, that makes
be
sense for in camera,
privileged.
but ex parte, I mean, it seems like the litigants should be able to know.
The litigants aren't the client.
Uh,
Uh, other
Right.
other
The one litigant is the
yeah,
client. That's
other than
true.
Wade, the litigants aren't the client. Now, maybe Wade's lawyer can come. They didn't say.
Right. Yeah, because you still do have the continuing privilege problem there. But
I have
lawyers
a
don't
question
like it
though.
when the judge knows facts that you don't know about your own case that he's using to rule.
I have a question though, King. Why is it? Why didn't Wade's testimony and Willis's testimony yesterday open the door to the defendants asking the court to issue a subpoena for her banking records that would establish whether or not she did withdraw? They can now total the travel records and with a round figure saying, look, if you look at all of the expenses that he charged on his card, and according to both their testimony, she supposedly reimbursed him for roughly half of those expenses. That amount is X thousands of dollars. She's testified that she compensated him in cash without being specific about where the cash came from. We think, the answer to whether or not that explanation is truthful or credible is in her banking statements.
Lies in her record. Yeah, right.
Does she show cash withdrawals that would account for the alleged repayment? If she doesn't, then her testimony is false, his testimony is false, and game over.
Because I think she told the story enough, vaguely enough.
Forcefully enough.
She told the story vaguely enough to where no matter what he finds, no matter what the defense finds in her bank account, she's going to say, well, the cash was already there. I didn't need to take it out the bank. I remember I talked about campaign funds. I had cash throughout, so I don't need to take it out. So it's not going to show up. So
yeah, I think the bigger that number is, though, the less credible that answer.
It's not that.
I agree.
It's not that big. It's less than 20,000.
No. Yeah, that's what I figured it just last night. It's got to be like between 18 and 24. I figured so. Yeah.
Well, I saw reporting that it was a week in Napa Valley. It was the cruises were $8,000 each. I think that ultimate number, and they were going every 3 weeks over a period of time. That number is going to be pretty big, and that's my point is though, until that answer came out yesterday, until that and one of the lawyers laughed when it came out. The judge admonished him, said, "If you do that again, you're going to be out of the courtroom."
Well, people, you can't do that when you're a lawyer. You can't react to people's testimony.
I would expect that somebody took pen to paper and said, let's look at these receipts again and come up with that total number and then divide it in half and say, okay, that's the cash she has to account for, or she has to stick by her story that I just keep that much cash in a coffee can in my strong box that my dad gave me.
No, okay. Well, I'm looking at some of the questions that we got, and here's one, King. This person says, can we ask about Miss Cross's cross of Bradley near the end where she told the judge that Bradley was a liar? Did that happen? Did this prosecutor tell the judge the witness was a liar?
Where she was going was his denial that he had assaulted anybody.
Oh, okay. So she asked that he denied it, and did she actually use the word liar?
Yeah, she did, and that was her. That was her justification for calling the last two witnesses, and she lost. She lost that fact.
Extrinsic witness. I see.
You set up a faux impeachment because you raised something that's totally collateral, having nothing to do with the issues in the case, and then you impeach him on that non-issue, get him to deny it, and then impeach him. That's where the judge drew the line.
Okay, so just so folks understand, so a lawyer might tell the judge that, Your Honor, we believe that was a lie, right? That answer was a lie, and I have witnesses here that can prove that it was a lie. That's perfectly valid conduct for a lawyer. it's really wouldn't be proper for a lawyer to say to the witness that you're a liar or that was a lie. So she didn't do that, did she?
I don't think so. No, she
Okay. She was talking
she
to the
told the
judge.
judge. Yes.
Okay. So it's appropriate for her to say that in order to try to persuade the judge that she gets to prove that. Now, he ultimately didn't let her do that. But there's nothing wrong with her saying that she thinks the witness has been untruthful, but you can't do that to the witness directly. So, okay. And then,
Which raises a question. Let's assume she's trying to impeach him and destroy his credibility with the judge. I'm not sure I heard anything out of his mouth that they thought was untrue or not credible.
right.
The only thing that he did was he sent a text to Miss Merchant, and she had the text there and read it to the judge.
Right. And he shouldn't have done that. That's a breach of his client's
But
privilege, but
but
okay.
that doesn't make him a non-credible
A
witness.
liar. Right. I agree. It doesn't. It doesn't. Okay. Now, one of the first questions that we got, so let's circle back to this because all of this stuff we've been talking about, and sometimes this is how hearings go, right? The lawyers and the judge can't really stay on the actual issues that are the ones that are really legally at issue. And this hearing had a lot of that feel to me because really what the judge has to decide is whether their personal relationship existed, whether Miss Willis was getting a benefit, a financial benefit from that through this contract to Wade's office. But most of this stuff we're talking about here really is like a food fight on the one hand, and on the other is really only going to questions of whether her explanation for the money makes sense or not.
I think you're wrong
Oh yeah, why?
because I think today the biggest issue that would be most certain to kill uh, Fani and Wade as prosecutors of this case would be
Right.
hard evidence they lied in court filings. And both of them are now being accused of doing that. Uh,
In filing to this judge to explaining
yeah,
the or
both
defending the
both of
motion?
them have
Right.
said that the affair didn't start until February, March, April of 2022, after Wade had been hired on this case. But
Right. Well, that's why I said the first point is whether they were having the
well,
affair. Right.
the issue they've raised is when did it begin?
Right.
And here you have Wade's former law partner, former lawyer, texting Miss Merchant saying that affair started in 2019, which is consistent with the first witness who testified.
Right. Which was her
So,
friend. Right.
if
Exactly.
you've got if the judge believes those people's testimony, and he lets in Bradley's testimony, and he can easily find, and he should find, that both Wade and Willis uh, filed false, uh, made false representations in court more than one occasion. They've lied under oath. They are off.
In this proceeding. But did he say anything about
He
that
did
too?
not say it, but that's where the defense is going.
I see. Okay, so that leads me to my next question, which is did he tell them he wanted post hearing briefings like Ship suggested
Yeah, and this
yesterday?
is a circumstance where we've all heard judges make determinations along the lines that say, that the Bradley and the first lady don't have any justification to lie,
Right. What's their
whereas
motive for
Wade
lying?
and
Right. Yeah.
Willis are motivated to lie
Right.
because of the consequences of
Of the
the
truth.
alternative being true.
Right. So did he say he wanted
Uh,
briefings on those
he,
issues or at all or
he did say he'd like to see briefings on the attorney-client privilege issue. Whether he wants brief on everything else, I don't know.
Okay. All right. So, but you said you thought the defense, that's where they were going. What, like in their summation? Is he going to hear arguments from them next week?
I heard the evidence and I heard the arguments, and that is definitely where they're going.
All right. So they affirmatively are asking him to disqualify them on the basis that they were not truthful in this proceeding.
That they committed crimes. They committed crimes, and despite that, they are representing the state in pursuing defendants on the same crimes.
Wow. Did you think the evidence warranted
Leslie,
that strong of a
Leslie, are you
statement?
there? Nobody's hearing you say anything, and you don't. Doesn't appear that you have a mic. Just says
I heard
host.
you.
Yeah, I can hear both of you too. Aaron, can you hear me?
I'm not hearing Leslie, so maybe my problem.
Yeah,
So
I
I'll
hear you
drop off
fine.
and come back.
Yeah, drop off ship and come back. So, did you think the evidence warranted that? Would warrant that conclusion, King?
It's a coin toss if you don't if you exclude Bradley. If you allow that in, I think it's a slam dunk for the defense.
Mm-hmm. That they lied about to the judge about when their affair started and that she's benefiting or not benefiting from the money.
But the fact that they lied, the fact that on the record, they could themselves be subject to criminal prosecution. At the same time, they're trying to prosecute
Right.
the former president of the United
All these
States
other
on
folks.
the same crime.
Yeah. Right. Yeah. Okay. And how did the judge seem to be taking that?
They didn't argue that. I read the
Oh,
briefs and I heard the
yeah.
case, and that
Yeah.
is number one, the main horse that the defense is riding. They're
Okay.
also going through the conflict issues, but they would very much like a finding that these two lied.
Okay. And are you still of the view, based on what you saw today, that you were yesterday, that he's not really going to go there, the judge?
Unless he's convinced. Well, that's an interesting question in light of what I heard today. Let's assume
Right.
that the judge meets with Bradley in camera, ex parte, and hears the whole story, and it's damned convincing. He convinces the judge that indeed Wade and his paramour lied, and lied on the record, lied under oath, time and time again,
Right.
and put the state through the misery of having to try this. Now, let's assume he decides there's no legal way to put that in evidence.
Right.
What does he do? I've always said that there's an easy out, which is appearance of
Yeah.
conflict.
Right.
Disqualify them because of the appearance without making a finding one way or the other on the lies.
On the lies and whether there's an actual
Right.
conflict.
Just by saying
So
that the fact of the admitted affair and the admitted credit card receipts creates an appearance of conflict. That's the easy out for the judge.
okay, I agree. So what do we think makes sense in terms of the disqualification? So both, one, if one, which one? I see people saying, well, if she's disqualified, her whole office is disqualified. And what's the thinking on that? An argument like, because it's not a case where like they have privileged information and the law firm is therefore disqualified because the partner knows things about, they're now suing their former client, right? And they had this client for a long time and suddenly they've decided to switch sides, and so the whole firm gets disqualified in that situation. That's an example where it makes sense to disqualify the whole office. The theory that makes sense to me, but this is the only one I can think of, to disqualify the whole office, is that it just looks so bad that the public can't have confidence that this office is prosecuting.
Now, I think it's statutory. I remember reading an analysis of this that
Ah,
says by statute in the state of Georgia, if the DA is personally disqualified, the entire office is disqualified as a result.
okay. So, but that's going to be the same public policy, right? That is just it just reeks if the actual district attorney gets disqualified. So we'll just boot the whole office out, start over with a new office. All right. Well, that makes sense.
It's actually not a new office. I think there's a state body, maybe under the AG.
Mm.
I'm not
Hmm.
sure exactly who's in charge, but a there's a slate of independent prosecutors that that
Hmm.
some way or another would come in and take over the case, evaluate the case,
Yeah.
uh, see who it should be shipped.
Independently evaluate
Correct.
it.
Correct.
Right. Yeah. I was surprised by the case I talked about last night. That Maryland had a similar. I was This is the first time I'd learned about it when I was using it in this case because I researched it. But the same kind of thing. There was a procedure for the Attorney General's office to step in that situation, and that's what we did in that case. So, okay, so Georgia has a plan for that. Well, what's your gut instinct, King, watching the judge? Let's say he says there's an appearance problem. Will he disqualify them both?
I think he has to do both. I, he, he might be able to justify just Wade, but I doubt it. I don't.
Mm,
That's illogical. If he's inclined to leave Willis alone, then I think he's got to find there may be evidence that would lead me in another direction, but I can't consider it. Therefore, uh, defense motion denied.
okay.
I,
Last night
yeah, I
you were
think,
leaning toward.
let me mention something here, Leslie.
Go ahead. Yeah, go
I
ahead.
think in the back of his mind, even if he comes to the conclusion that King mentioned that, I believe the story, but under the rules of evidence, I can't get it in the record. I still think in the back of his mind, he has got to be considering the reputation of the judiciary of the state of Georgia, and that this is played out as a farce before the entire country. And the people behind this have beclowned themselves in the manner in which they've handled themselves.
Spectacularly.
And the only way really to rescue the reputation of the state's criminal justice system is what I mentioned last night. If this case is strong enough, it doesn't matter who the prosecuting office is.
Right. It'll hold up under second review. If it's not, it won't. Yeah. Well, that's where I was going with King because King last night it sounded like you thought this judge might have trouble getting himself to disqualifying them, perhaps for his own career or professional
And,
reasons.
he's instinctively he's against this disqualification. He's in favor of
Hmm.
giving all the benefit of the doubt to the state and whoever the state wants to, and the people elected to pursue the case. But he's heard enough in these 2 days, and he's going to hear more when he talks to Bradley. Uh, that Ship may be right. He may he may decide, even if he can't figure out how to get Bradley's evidence in, uh, he still has that uh, golden ring to grasp, which is appearance of
Hmm.
conflict.
Right.
Uh, you know, and he could easily go that way. I still think it's 50-50.
This was a question that was asked that I don't know the answer to because I don't know really any Georgia law on this point, which is could this be appealed, do we think, interlocutory?
No, I come down hard. No.
Okay.
What do you think, Ship?
All right.
Ship?
Yeah, I think it's a discretionary judgment on a record that he makes. And the appeals court is not going to review a different record. And I think the standard would be, I mean, assuming that the standards of review are the same in Georgia state courts as they are in federal courts, the standard review would be abuse of discretion. And I
Yeah.
don't think a 3-judge panel under the record would be inclined to say that he, acted beyond his, or that he abused his discretion.
I don't think that. I don't think
Right.
that take.
Well, that's very possible.
Yeah.
But
Yeah,
but
I
but
tend to have the same
the state
view.
is the aggrieved party, and the state is
Right.
losing the prosecutor in the jurisdiction where the crimes were allegedly committed.
Right. Well, that's where I was going to go with it, which is I'm trying to remember in my Maryland case if there was a statutory like right of appeal on this kind of ruling. So it general applying general appellate principles, the answer is probably no, but let's say with the caveat that there might be some Georgia specific statutory law that might make it appealable, so that would have to be researched. Aaron, did you want to jump in here? Did you have anything else you wanted to comment on from your perspective as an investigator?
Well, I was just sort of wondering what the judge's view would be. From my view, I don't think anyone can be clear whether they broke the law or not.
Right.
Like,
I agree.
and so if I'm
Not
the
based
judge,
on that record.
I'm thinking, oh my gosh, I don't want to say there's no conflict, and then 6 months from now it proves that she's up to her eyeballs in corruption and being indicted herself. That would not look good for me either. So I just sort of think the easiest thing to do would be just to say, well, I can't, I'm not going to take anyone's word for it. It just looks like it's bad. And that's, I'm not going to make any determination about any of this stuff. That seems to me the easiest way to go in all this, because I'm looking at this thinking this is all very suspicious. I cannot tell, and I think the judge, at least in federal courts, they would always sort of side with the prosecution mostly on, these things up until a point. But this seems really, really suspicious.
Right, but like we were saying earlier, but it's not conclusive by any stretch of the imagination based on what we know so far. So I agree with you. But yeah, I wonder if it would enter the mind of this judge that what will happen if a year from now Fanny gets charged with whatever XYZ, right? But by then maybe so much water will be under the bridge. We'll see. Did you guys want to talk for a second about what happened in New York to the former president today?
Let's go.
Okay, so I will say I think that is probably a violation of the Eighth Amendment ban on excessive fines. Does anybody disagree with that?
Uh,
What we're talking about is this New York judge sticking Trump and his businesses with a 340 million, isn't it, dollar fine?
340, 350, 360.
364, I think, was the number I read.
Yeah.
Okay, 364.
Eighth Amendment is the start.
Right. But the reason I mention that is because one of the questions we had, because people were hoping we'd talk about this, is whether or not he could take that case to the Supreme Court. And I was explaining that, well, to take a state court case to the US Supreme Court can be done, but you have to have a federal claim or right or statute or constitutional federal constitutional claim, right? So the Eighth Amendment would give him that if we think that that applies. I personally do. What do you guys think?
Well, it's a civil case, so I think that the only way it gets there is after the highest appeals court in New York, which I think is called the New York Court of Appeals, after they review it and make a decision. Then it's their decision that actually gets appealed.
Yeah, I think Ship's right.
Right.
He's got to go. He's got 2 steps of appeal in the New York courts before he can jump to the Supreme Court.
Right. I wasn't saying he could jump to the Supreme Court. The question is, can he ever get to the
Yes, he
Supreme
can, but
Court?
he's
And
got to go.
yeah, he
He,
can if he's got a federal issue.
he's got to
Right.
go to the New York Supreme Court and then the New York Court of Appeals, which is the top court. And the first issue is, does he have to post a bond?
Right.
And what if he doesn't? And what if he can't? Can he?
Well, apparently today there was a merger approved of two companies, one of which was Truth Social,
Truth Social.
and Trump's stake in Truth Social as of today is valued at $4 billion.
So maybe he's like, Bon Schmond. Bring it
Is
on,
that
babe.
under the Trump org umbrella?
I don't know the answer
I
to
think he's got
that,
a
but
personal.
wasn't
I
he
think he's got a
personally
personal
fined?
stake in Truth
Yeah, I think
Social.
it's both personal and his
Okay.
business. Yeah. Yeah, so he could post, and only one party has to post if they cover the whole amount, right? So
Somebody has to theoretically come up with cash, uh, or
property
give
or bond.
get
Right.
a court to approve a property bond. But if
Right.
it's cash, if they
Well, you know what? This judge found that Mar-a-Lago was worth 18 million. There's part of it. All right. Um, so I haven't been following that case close enough to know if there's any other federal issue. If it's only state court issues, then he can certainly appeal up through the New York state court system. To take it to the Supreme Court of the United States, though, which was the question, there has to be some kind of federal issue. So you could maybe do possibly a due process, definitely Eighth Amendment, maybe a substantive due process. That's one of the hardest arguments to make in federal court. But so the answer is maybe on whether he could go to the Supreme Court for that one.
he's got all kinds of issues to raise certainly in New York appeals courts, and
Right.
uh, and he should win. He should get this thing tossed out. Uh,
Which one, in Georgia
the
or New
New York.
York?
My question is how many companies are going to be leaving in the meantime?
What, for fear that they'll get prosecuted for the same thing? I mean, they're not going to, right? So
Yeah,
Uh,
I think the answer is zero because
they're not
the
Trump.
statute that was used, it does exist, but I heard an analysis of it on a podcast. So basically, this statute exists for litigation between private litigants, not
Right.
to be enforced by the attorney general. And it had never been used by the attorney general to be enforced in this
and
manner before.
it's a consumer protection statute. These banks,
Not a commercial
these
entity
banks that
protection
were
statute.
supposedly victims are not consumers.
Right. And weren't even victims,
We're
apparently.
not victims.
So there you
Certainly weren't
go.
consumers,
Right.
and they denied they were victims. So it's got problems.
Yeah, those would all be state court arguments, though,
Right.
right?
And,
Yeah.
and the state courts have got to do something, because if they don't, they will lose some business. I'm hearing
So that
I'm
is
hearing
actually,
through the grapevine that there are companies thinking seriously about moving.
well, and I think actually that's a great point, King. I was thinking of the fact that it had never been used before. It was used here only to single out Trump, therefore it would never be used again. But if it's validated by the courts
Oh,
in
and
New
it puts
York,
money in their pocket.
then
Yeah.
everybody's at risk if you end up on the wrong side of the AG or a county DA, and because this was the state AG, not the Manhattan District Attorney. That's
Right.
correct. Um, yeah,
Right.
so
Yeah.
a company might not ever know when they end up on the wrong side of the AG and find themselves targeted with this kind of effort.
Right. And the government loves schemes like this that put money in their pockets. And that was one of the other questions we got was, well, if the banks weren't victims, who gets the money? The government gets the money, all that fine money goes to the state of New York. So yeah, King, you may be right that the New York business community won't be so happy
I
with
mean,
that.
don't kid yourself. There are these state level cases of targeting big businesses, big bad businesses, kind of go in waves. And you
Yeah,
get a
it's true.
series of them, and then they'll kind of die away, and then they'll come back depending on who's in office, and
And it rotates by
and,
industries,
and
healthcare
I
one
can
time and banks the
yeah I can
next.
tell
And
you
yeah.
the corporate CEOs and their corporate lawyer, they look at that stuff carefully. They're watching it.
Right, because they have to, right? Because their underwriters are looking at
Exactly.
it and their auditors are looking at it.
They know where to stay away from. They know about the venues in this country that are full of trial lawyers. They're going to take as much as they can. I mean, these are
Yeah,
not secrets.
right. And they're sophisticated players. So, yeah. Okay, well, we're getting close to the end here. So, King, let me ask you to wind us down with, is there anything going to happen on Tuesday in this disqualification case that'll be interesting enough for people to watch, or is it effectively over with now?
They're going to produce the phone records. I think it's going to be ministerial. I don't.
Okay.
If there's going to be argument, I missed it because I
Okay.
but I'll let you know, Leslie, if I was wrong.
Okay. Can you, is it possible to check that docket? Is it publicly?
No,
It must
I
be.
don't have access
No?
to it, but there are
All right.
some
I'll see if I can. Yeah.
reporters who keep up with it. So
Yeah. I think actually I signed up for that. So I will check that and see if maybe the docket will tell us if there's going to be oral argument on Tuesday. If so, I'll tweet it out and let everybody know. So, okay, guys. Well, thanks as always. Ship, your microphone issue, it was much better tonight. It was greatly appreciated.
I was driving, so I was not able. That's when I wasn't participating. I was just listening, but not using
You weren't pumping iron in the
not
car?
using over the ear headphones. I think is a big improvement. I still did not have time to set up the mic tonight, but
Aha.
I'm just using earpods right now, which is simpler.
Okay. Well, all is forgiven. So I will let you guys all go, and we'll when the next thing happens, we'll meet again.
good night, all.
Good night. Thanks, Aaron. Bye. Bye,
Bye.
Ship. Bye, King.